Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican, please. Very sloppy.
Is that correct?
I didn't ask you to interrupt me. Oh, for Trump's sake.
Good morning, good morning. Welcome to the Court of Public Opinion. It's almost afternoon. I know some of you are like, check the time. Check the time. Good morning. Happy Monday. Happy Monday. It's great to be here. It's a beautiful day out there. A little cloud, a little smoggy. What is that? I can barely make the mountains appear. There we go. Let's keep them like that. There we go. All right. Good morning. Good morning. It is Monday. The birds are flying. The trees are beautiful. Bugs are singing. I don't know what's going on outside. I haven't been out yet. But we are here. We're here. I'm excited. Oh, I need to chat. That's important. There we go. Now we're cooking with fire. All right, a big shout out and a welcome to Ashley, who was first in chat with 2 jars of spicy maple bourbon pickles, which I don't know who told me because I didn't check the name, but somebody texted me this morning and said, guess what I found at Aldi? Aldi's now carrying the spicy maple bourbon pickles. They've come around, which is exciting because I have an Aldi in my neighborhood as well. Not now, not here, but back east. We have some Sarah Boone to get to. Yes, we know. Don't spoil it for everybody. We'll get to that in just a second. But there's a brief Sarah Boone hearing we're going to cover and explain in detail. That's coming up. Let's see. Welcome. Good morning, all. Good morning. Good morning. Good morning. Let's see. Red Pen. Good to see you as well. It's all good. Good morning. Welcome, Candace. Hello, Candace. Welcome, Candace. Viva. Welcome, Texas Nana's here as well. Hope everyone's football team won over the weekend. Go Sports, yay. I can't start my day until I hear, oh, for crumb's sake.
Oh, for crumb's sake.
There it is. It's Tuesday here, says Apple Treasure. That's how late you are. It's Tuesday. You must be in Boise. Not yet. I do apologize. This morning, went to go live stream the Sarah Boone and everything with y'all. And our home network here, in our Airbnb, which we have no control over, we just try to connect to, had completely reconfigured, and all the IP addresses were different, and the way it shares the internet and allows other devices to see each other was different, and I had to rebuild, digitally wise, all the connections for all my devices, and then reconfigure each of the programs that uses those connections. So it's been a busy morning this morning, even though I wasn't live streaming. I was trying, but the internet was broken. Let's see. But we'll catch up. We'll catch up. It's Tuesday. It is Tuesday. Oh my goodness. That would explain why I was at the planetarium yesterday on Monday. It's Tuesday. It feels like a Monday. That's what it is. Okay, it's Tuesday morning, but it feels like a Monday. It feels like a Monday. Oh my goodness. I honestly thought it was Monday for some reason. That's terrible. I mean, it could be worse. It could have been like Tuesday and I thought it was a Wednesday, and then you'd always be a day behind. But now I've lost a day of the week. So now we're super, super far behind. That's crazy. I just realized, like, everyone was saying it's Tuesday here. I thought you were mocking me for how late I was. Like, hey, you should have been on Monday, but now it's already Tuesday. Maybe you were. I missed y'all yesterday. I did a brief live stream from the planetarium, which was a blast. Oh my goodness. Clark Planetarium, Salt Lake County has got it put together. That is a fun place to go. It's free. It's free. And it's just crazy. I realize looking at it now, most of the interactions are basically video games. And that's why kids like it so much. But they're science video games. So it's fun. All right. We are back. Let's see. Doesn't take a lot to confuddle me, says Sharon. Happy Tuesday morning to you. Welcome. Good to have you here. Let's see. We've got a couple things I have to do here before we do the birthday list. Kim R. gifted a membership this morning. Thank you very much. Tisha S. says hello, or just hell, y'all. Either way. Gail Pett. Good morning, everyone that is here on the best channel on YouTube. It's been fascinating being here for a year and a half, 18 months. Congratulations. Holly Mack as well, 14 months. Says best 14 months. Happy Tuesday, all. I love RA in this channel. Thank you all. Thank you. It's been a wonderful week, but I tell you, I'm excited to get back to North Carolina and get back on my regular time schedule, because staying up late here on the West Coast does not work with early courts on the East Coast. Babs Austin says, I've been waiting for a year and a half to be here. Yes, look at that. Orange Courthouse, Babs. Congratulations. It looks absolutely great. Green-Eyed Cat says, I didn't get to do this last time when I expired. LOL, what a fantastic month with y'all. Congratulations. Looks like your courthouse has changed color for the first time, which is first of many. Green-Eyed Cat, good to have you here. Welcome. All right. We have some birthdays, I believe, to get to. If anybody has any birthdays, and if we missed it yesterday, please add yourself to the list today. Make sure you do it right away, though, because it's singing time, and we don't want to stretch that out too far, because we have some fun stuff, especially with Sarah Boone, to do. Where's my super source? Okay, I tried to get all these buttons working, and everything was just a pain this morning. Oh, it was a pain. Okay, box. Let's see, where is? I need camera 8. There we go. Super source. Okay, so it's going to be camera 3. Box 3 will be 2. I think that's everything we need. Oh, box 4 will be MP2. Oh, can't find what I need. Hang on just 1 second. Media, this one's going to be right there. All right, now we're good. All right, let's take a look here, see if we have any birthdays. I think I had the sounds turned off if there was a buffer. Oh, there it is right now. Perfect timing. Job's done. Let's see, Michelle, Price is Right, Dana, Geraldine, Kathy, Gloria Marseg, Noreen B, Ruth Buck, Gailey May, 80s Music Man, Joan, KRH, all celebrating their special day. Wow. This might be a new record for how many birthdays we have to sing to today, which is wonderful. Let's see. Welcome back, A. Colburn. We're about to sing the birthday song. If you've missed it, here's what we do. This is how it works. First of all, look outside. It's beautiful. It's absolutely gorgeous out there, and it should be, because it's wonderful people's birthday today, or at least we're celebrating today. So if you would join with me in singing with them or to them the happy birthday song, and we do that. We practice a little bit. Job's done. There's the job's done. It's finally catching up by warming up together with warm up with me, if you will. There we go. La 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 la. There we go. Now we've got dancers at the ready. Everyone's going to sing. Stand up. Blend your voice with those of your neighbors. Deep breath. Project to the back of the room. Here we go. All right. Happy birthday to you. Happy birthday to you. Happy birthday, Michelle. Price is Right. Dana, Geraldine, Kathy, and Gloria Marseg. Happy birthday to you. Okay, so we got maybe half, closer to a third. So verse 2, we're going to start with Noreen and jump in and see how far we can get here. We might have to do a verse 3 as well. Happy birthday to you. Happy birthday to you. Happy birthday, Noreen. Ruth Luck, Dave Major, 80s Music Man, Jonah KRH. Happy birthday to you. What a day. Wow. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 people we're singing happy birthday to. That is a ton. That is a ton. To all those who are celebrating their birthday today, I realize this is your special day. There are a million places you could be, a million people you could be with, but you've chosen to celebrate here with us. And the privilege and pleasure is all ours. Thank you very much. Hopefully we can make your day a little bit more specialer. Make sure you help yourself to pancakes at Denny's or IHOP or Village Inn, which apparently offers breakfast all day long. So you can go there late and still get your breakfast pancakes, which is wonderful. Happy birthday to all the wonderful happy birthday people. Wonderful day to celebrate. We're going to turn the music down eventually, probably with a drum solo, if we get that far. We've got to go 2 more verses before drum solo. But just because the music stops does not mean the party must stop. We can continue celebrating. And what a day to celebrate. We've got Sarah Boone in court this morning. It's actually for a hearing. She's got a lawyer. That's going to be fun. So that's a birthday present to you. We're going to go to that first here in just a minute. See, that's the most since we made up a bunch of names the other one. Okay, drum solo's coming up. Adam, you guys made up names and made me sing them? Oh my goodness. Okay, drum solo. Get your drumsticks out. Here we go. Beautiful. Beautiful, beautiful. You guys made up names? And made me sing to made-up people? I mean, I'm sure there was somebody out there whose birthday it was. Can you believe Adam Nusky made up names? Adam, free sample user, made up names. Yes. Oh, my goodness. How's long until you grow out your stash? I'm actually probably going to shave it off again today. I think I'm going to go babyface for the wedding. Just for this reason. First of all, the wedding is this week. Right? So this week I'll be up in Idaho. We'll be up there. I said we were going to be up there for a week, but I checked the schedule. We're actually only going to be up there. I'm going up Friday. And so Friday I'm probably not going to live stream because that's the wedding. Friday, Saturday, Sunday, and then Monday I'll be back in Salt Lake overnight, and then we're driving home. So I guess we start Monday, but we only drive to Salt Lake. That's a short day, and then we do long days driving home. So we've got to figure out how we're going to do a couple things next week because, we've got some spicy Judge Cedric Simpson stuff coming up, I think, that I will be driving for. And so I might try to do the live view. I might try to have Mrs. R.A. drive and I live stream from the passenger seat, which would be crazy. I'm calling it right now. All right. I'm on 1.5 super speed because I'm late as usual. However, the birthday song is epic on 1.5. Au contraire, please hop on Friday morning. I can probably hop on every morning. I can do a birthday song every morning. Dodie Sweeney, welcome to the gallery. Dodie, thank you very much. Love that orange courthouse. Let's do this. Well, Samantha Terry is getting medical treatment for pulling a muscle doing the high kicks during the birthday song. Samantha, it looked fabulous. I couldn't tell you were injured. You really gave it your all. We're going to jump over to Sarah Boone's hearing. This is what's happening. Okay, a quick update on Sarah Boone. For those that don't know, the hearing happened just moments ago, and she has a lawyer. Finally, and this lawyer is pro bono. What that means is he is not getting paid. Not only is he not getting paid by Sarah Boone, he's also not getting paid by the state. He's all in for free, okay, which is cool because that's the only way she's going to get a lawyer at this point, I think. So we've got a pro bono lawyer, and he walks in, and the first thing he wants to do is sort of slow things down a little bit because, oh my goodness, October is coming very quickly, and that's the date the court has set for trial, and he just barely showed up. So he's going to try to slow things down with the judge. We're going to see how that goes. Sarah Boone will be there in court watching, and we're going to have all that for you here in just a second. Let me get the buttons ready. Holly Mack says on celebration of 80 Music Man's birthday. Happy birthday, 80s Music Man. And thank you, Holly Mack, for a generous super chat. It's unreal she got a pro bono attorney. That's the only... The guy must have just been like, look, somebody has to step up. Really? I'm the guy? Fine. That's how it went. Donnie, happy birthday to your cat. Wonderful, wonderful. Happy birthday to your cat. Okay, I'm trying to get all my buttons ready here. Let's see if we can get the sound. I think we have sound. I need to turn off. There we go. It's not the best audio, but we'll make it work. Hey, there she is. There she is. Sarah Boone coming in. Back in shackles now that she's represented because she doesn't need to take notes anymore. So they fixed that problem. Shared a little joke with the guard and glance at the camera. Double take at the camera. Wow. I don't know what the guard did or said, but that sure made her day. Now she's grumpy. Okay, it went from good to bad, just like that. Good to bad. The cameraman improperly adjusted his camera, and we now are leaning a little bit. I'm not sure why, but we'll give him just a minute for the state to show up. Thank you for everything, RA. I'm in the hospital indefinitely. Lurk for now. Katya, I am so sorry. Please get better quickly.
Judge, I'm James Owens, and I'm representing Sarah Boone.
Sir, good morning. Pleasure. Ms. Boone, good morning. Could you please state your, raise your right hand now. First, going to go ahead and swear you in.
Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, good morning. Could you state your full name and date of birth for the record for me?
Sarah Boone, 101077.
Good morning, everyone. We are here on several different items. The first is the court's notice of hearing that was sent out last week. The first issue on that was addressing the viewing of the physical evidence here in open court. On August 5, the court entered an order setting forth certain deadlines and scheduling, including the viewing of the digital evidence no later than September 3, and the physical evidence viewing to take place here in open court on September the 3rd, and a schedule for objections thereafter. The digital evidence review took place on August 9th, and the August 23rd deadline for objections has since passed. On August 14th, the court was advised of an alternative arrangement and advised the state to file a notice reflecting when and where and how that review would have taken place. I did not receive or see such a notice in a court file. Mr. Cashore?
Yes, Your Honor. We were not able to file the notice prior to today. However, on Friday, August the 30th, we were able to have that evidence review of the physical items with Ms. Boone at the Orange County Jail.
Okay, all right. Ms. Boone, can you confirm if, in fact, that viewing took place?
It took place.
Okay, all right, very good. And who did it take place between the state, yourself, and was Mr. Lane with Prison Break Investigations a part of that viewing?
Correct.
Okay, all right, thank you very much. Also set for hearing this morning was defendant's motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense. That was filed on 14th. The next day, August 15th, JSCS filed a response to the motions for payment of costs and appointment of a neuropsychiatrist. Paragraph 10 of the JSC's response reflects that the JSC will not be participating in this hearing. Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion for costs? Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist, Dr. Julie Harper, who was on this case previously. I believe she saw Sarah Boone about 6 times at the Orange County Jail. She was working under the direction of the original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial, ready to go, and then at the last minute he withdrew. I tried to call him a couple of times. Haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer. But we don't need this neuropsychologist that Ms. Boone had requested, but we do need a reappointment forensic psychologist, Dr. Julie Harper. I've spoken with her a couple of times last week. I text messaged her 4 or 5 times this weekend. She is in agreement to handle the case, to reopen her file. She has sent me her records. I have reviewed them. I've met with my client. I think my client meets the criteria for battered spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, and hopes that she's going to be of that opinion. In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berkeley, who is from my area, Pensacola, is who I am recommending to be appointed. What was his name again, sir? Michael Berkeley.
He's from Pensacola?
I talked to the judge yesterday or last night. I don't know if they're in the court file yet.
I did not see them this morning. I did see the motions.
Okay, hold on. He is from Pensacola, Florida? That is a long way to go. A long way to go down to Orange County. Wow. Okay, I didn't realize he was out of town that far. All right, sorry.
Can I approach them in?
Yes. State, have you seen them?
I just saw them briefly this morning prior to the hearing.
Thank you. The only thing I saw in the court file, counsel, when I was prepping last night was the motion for statement of particulars. It's called on September 2. I have not yet seen these motions.
Judge, I also filed a motion for additional discovery. I don't know if that made it through as well.
Was that also filed yesterday, sir, sometime in the evening?
It was filed at 8:30 yesterday morning.
So I have a motion for statement of particulars filed at 8:10 yesterday, but I do not have the motion for additional discovery filed at 8:34.
I don't know why the court was not able to post that, because they were filed one right after the other. One's in the court file, the other 3 aren't.
They were all filed yesterday, 19.
Certain things auto-populate and certain things have to be accepted.
Okay.
The statement of particulars and the additional discovery were filed yesterday morning. The motion to appoint the crime scene reconstructionist and death investigator and the motion to appoint the forensic psychologist was filed at 6:10 p.m.
I do see that.
We have sound.
As the court previously identified, JCS chose not to participate in this morning's hearing by virtue of their response filed on August 15th. They are not here. Your motions for these various experts report that they were sent to all persons on the service list through the e-portal. But I don't know how I can address these this morning without having JCS here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these need to be addressed. Be advised, this is a trial week for the court, as is next week, but I will do my best to endeavor to try to get these heard as soon as possible.
Judge, I have, I filed my notice of appearance on Friday, and I've spoken with Dr. Berkeley 2 or 3 times this weekend. The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Berkeley. I believe he has the autopsy. We cannot find the autopsy photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation. So I know time is of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the status of the provision of the autopsy photographs and the crime scene photographs and providing them to counsel?
We provided all of those things previously, obviously, to the defendant, which has been greatly discussed already. When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovery, which is easily available to him, just so that he could quickly have that and not have to worry about
to him?
If he wants to come back to my office, we can do it this morning / this afternoon.
Is your office in the building?
Yes, it's in the courthouse.
Right there. Come out the front door, make a left.
Okay. I don't have a USB with me, but I'll find one. This morning, we'll get that done.
Okay, I appreciate you both. With regard to the motion for additional discovery filed yesterday, September 2, 8:34 a.m., State, give you the opportunity to review this.
I just reviewed it just now here in court this morning. The state was going to request an opportunity to respond to both this motion and also the motion to the statement of particulars formally in writing, given the lack of time we've had to prepare to make a formal response.
Sure. And how much time, Counselor, would you like in order to file a response to the motion for statement of particulars and
She is so happy to have a lawyer.
Motion for additional discovery?
I would ask for at least a week.
Any objection?
No objection.
Okay, all right. The state shall file a response to both the motion for statement of particulars and the motion for additional discovery no later than the close of business 5 p.m. on Tuesday, September the 10th. And if hearings are necessary, we'll coordinate those. With regard to the defendant's pro se motion for payment of costs and appointing neuropsychologist to assist the defendant in preparation of the defense, the court's going to deny that as moot based on Mr. Owens' representation. With regard to the motion to appoint crime scene reconstructionist and death investigator and motion to appoint forensic psychologist, State, are you intending on filing a response to these?
No, we're going to take no position on those points.
Okay, all right. I will have Ms. Barrios, I'll ask the clerk to see if we can push these through the portal today so that Ms. Barrios can reach out to JICS and see if we can get a time frame on when they may be able to provide a position statement or a response to those motions, and then we'll coordinate a hearing respectfully.
Judge, I'm going to want to add one other forensic psychologist, make a request. I want to make sure that there's not an issue about my client Sarah Boone manufacturing the defense. And there's a second doctor, Dr. Michael Brandon. Dr. Michael Brandon.
B-R-A-N-N-E-N?
He spells it B-R-A-N-N-O-N. He was the forensic psychologist in the Marsha Thompson case. That was the Palm Beach County first-degree murder where she shot and killed her husband, shot him 9 times. He was laying on the couch and was acquitted of first-degree murder back in July of this year. That was a 2019 case, so that took a while to get to trial.
Shot it 9 times while laying on the couch.
Dr. Brandon testified that a battered woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger. In addition, Dr. Brandon said victims of repeat violence may fear death in situations others would not.
And?
Says the judge.
I've tried to reach out to Mr. Brandon this weekend unsuccessfully. And my intent is to reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours. That's the only other witness I'm going to need an appointment for a forensic psychologist. So 2 forensic psychologists, Dr. Julie Harper, Dr. Michael Brandon, and then the crime scene reconstructionist, Dr. Michael Berger. And then in addition, I would like Billy Lane, who's seated in the audience. He is the investigator on the case. Because of the claims that we're making that she's a battered woman, we need evidence to corroborate that. So there's a lot of history between her and Mr. Torres involving the apartment complex, which is in Winter Park. That was 4 years ago. The ownership of that apartment complex has changed hands, so it's going to be somewhat problematic trying to get information about who all the tenants were that may have witnessed some of the violence involved in these two, as well as we're trying to get together the 911 calls that Sarah made and others have made about the disturbances between that couple. So he's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports of the prior domestic violence arrest of Mr. Torres, as well as the officers involved and their body cams to see if there's any evidence on the body cams that would show injuries to Ms. Boone. So we've got a lot of work to do, but I believe it's necessary for us to prove a viable defense of battered spouse syndrome, that we have cooperation. It's going to take a little bit, but I do need the appointment of that expert. He tells me he's already on. I'm going to have to file something else because it was under Sarah Boone. Now, as the attorney of record, I'm going to have to file something. He says he's still got plenty of hours to work under that original cap. So I'll be filing something today or tomorrow as it relates to that. But that's the only other. Of course, I've been retained, so I'm not going to make any claims for attorney's fees. I'm not making any claims for travel costs, just for these witnesses.
The JCS has already approved, I believe, $10,000 in investigation fees and $1,000 for other costs associated with Mr. Lane. That was at one of our previous hearings. Now, that was when Ms. Boone was representing herself pro se. I can't imagine JCS may change their position with regard to those costs since they've already said yes, but file it and we'll try to tee it up for hearing as well to see if they have any position, or it could just be the order can be modified to extend to you as counsel for Ms. Boone.
Thank you.
All right. That takes us now then to your motion for continuance file that was filed on August 30th. Courts had the opportunity to review that motion. Any other argument or statements with regard to that motion? Mr. Robbins.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it, but it is critical to my theory, our theory of defense, battered spouse syndrome. And as you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement, that was just between the two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg, and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls, and arrest reports, and provide that to the 2 forensic psychologists for them to help formulate their opinion as to whether she is, in fact, a battered spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day yesterday, as well as the other 4 times that I've met with her. I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not, involved. I don't believe you were involved at that time. Or may have been.
Not me.
Okay.
My predecessor was.
But I think it was almost ready to go. And for whatever reason, he withdrew at the last moment. And then here we are. But I think it's prejudicial if we're not allowed to present the defense that we believe we have a viable claim. And I would respectfully ask, I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles sometime at the end of the year or first of next year. I can be ready. I think that will give enough time for our experts to visit with Ms. Boone.
He wants to delay court.
And formulate their opinions. I'm sure the state's going to want to take the deposition. I think they may have a right to hire their own forensic expert to go out and interview to see if they agree. But that's just going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance.
Got 1 month.
Mr. Padilla has done a lot of the work. My understanding he's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 banker's boxes. She has not gone through all the discovery. We've tried, but we have not made it. My understanding is a lot of the 2-hour interrogation with the Sheriff's Department has been transcribed. I haven't reviewed that, but we do have a problem with that interrogation. Now, that's why I made the request about the policy. Our policy in my county, Santa Rosa County, is a little bit different. And based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So, because of that, but ultimately because, yes, could I be ready for trial on October 7th? I believe I could, but not without the battered spouse defense, because I don't believe my experts would be ready. And so that's instrumental in our defense.
State, do you have any position?
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several of Ms. Boone's previous attorneys, and in fact, the state did retain an expert, Dr. Tanya Warner, who's on the state's witness list in this case in anticipation of a potential rebuttal of an attempted battered spouse defense. The state's position would be that we would oppose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file the notice of intent to rely on the battered spouse on Monday. We can't wait a week that the time has expired. If the judge doesn't continue today, he wants to have a conference next week, but it's too late for him.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial?
You have to give it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said it, 30 days, not 60, not 90, not 120.
Says you've got plenty of time.
You can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist, that makes that claim. I just can't say, hey, we're going to rely on it, and I'm putting you on notice. I've got to have some kind of authority. I'm not an expert. I think she meets the criteria, but I'm not a psychiatrist. I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can file that in good faith. I can't do it without Dr. Harper. She needs more time. Dr. Brand needs more time.
All right, thank you. State, anything else?
No.
All right, thank you very much. All right, Mr. Owens, it seems like you've already started to dive into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order and adjudged portion, that trial specially set for October 7th, 2024, and that it would be not continued for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed, and that by your own representation you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020 under Mr. Padilla's representation of Ms. Boone. At no point in time did Mr. Padilla file a Category A witness list disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone as addressed in open court on February 9, 2024. And as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who had expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz Mr. Bankowitz, on July 17, 2023, again by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton v. State 220 Southern 3rd 1152 and 1176, and Barlow v. State 221 Southern 3rd 562 at 569, there's a 2-part test determining the need of experts. We're not going to be addressing that today, as you sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here and had the opportunity to review those. In Ramos v. State 75 Southern 3rd 1277 at pinpoint 1281 by the Florida 4th DCA in 2011, citing to Lawson v. State 884 Southern 2nd 540, also by the Florida 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change of counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation of trial is counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Bankwitz, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representation in those motions and the findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations in various hearings, and prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had the discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court-appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986, with a duly elected public defender of the First Judicial Circuit in the state of Florida from 2009 to 2012. You've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the battered spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. In considering all the factors as set forth in terms of the state 311 sub 3rd 185 at 10.189, Florida 2nd DCA 2020, your motion for continuance is denied.
Denied.
Matter of this trial is still set for October 7th. We will have pre-trial the 6th to 27th. Pre-trial in this matter, or trial case management will still be set for September 26th at 9 a.m.
Judge, a couple of things. Number one, I have a full practice. I've got a docket day this afternoon in Santa Rosa County before Circuit Judge Scott Duncan. I've got 12 clients that are pending. I've got other people covered it, but I do have a full docket. If we set some of these hearings involving my motions, could I be allowed to hear by Zoom?
Any objection?
No, Your Honor.
The only request that I would have, sir, is the rules of general practice require a notice regarding your appearance. If you could just file a motion and provide a form order, I'll sign it and you can appear virtually. There's no reason for you to drive all the way down from Santa Rosa County for all these hearings when we can appear virtually. JAC, as I imagine, will be appearing virtually for some of these motions with regard to the experts. So as long as you file a notice in advance, sir, I've got no problems with that.
Judge, in that pre-trial order, it mentioned, I thought, that the state attorney was supposed to meet with the defendant and the defendant's investigator and review all the digital evidence from the order. That's the way I read it. They were supposed to sit there all together and watch every potential video exhibit the state was going to introduce at trial. That has not happened.
Isn't that the old motion?
The deadline for that, I don't mind extending that because I'm going to need to look at the evidence.
With regard to the digital, the deadline, you are correct, sir. The deadline was today, based on the August 5 order. If it did not happen before then, as I outlined at the beginning, there was a change to that process. A thumb drive was provided in open court to Mr. Lang on August 9. He then provided it to Ms. Boone, a thumb drive of the specific digital evidence that the state is seeking to admit at trial, based on the witness and exhibit list that was filed under seal on August 9. Ms. Boone had the opportunity to review that information at that time.
All right, I'm going to ask for more time for me to review the digital exhibits they intend to introduce. I don't know if they've been redacted. I don't know if they're the originals, but I'm going to need to look at that. I went to the jail yesterday. I had to let them know in advance that I was coming. I believe my secretary had emailed them and said I wanted to bring in my laptop and my phone to view evidence and whatnot. I was not allowed to bring in my laptop and phone yesterday for 3.5 hours. So I didn't get done a lot of the things that I wanted to get done within that period of time. Probably would have stayed there a lot longer if I would have had that capability. So I would ask for some more time to be able to for me to look through the digital evidence as to what I assume it's being redacted. I know some of the audio in terms of comments my client made, comments the officers made, some of it is, in my opinion, improper to be presented before the jury. So I'd like some extra time to be able to do that.
State?
I'm not certain, is he asking for a continuance again? What is the extra time that he's seeking?
What is it you're asking for? Extra time to do what?
The way I understand the order, I'm looking at paragraph 4 of the scheduling order and notice of hearings that, Judge, you signed August the 5th. Paragraph 4, the state's digital evidence will be reviewed with the state's investigator, the defendant's investigator, no later than September 3rd, 2024. This evidence viewing can be done in advance of September 3rd deadline. The state shall provide the defendant USB drive with the station. They never viewed it with my client in its entirety. As the order states, they were to do by today. So the state attorney has failed to comply with the court's order.
Tamara, thank you for the gifted memberships.
To do it either. Can we reset that deadline?
On August 9th, Mr. Owens, we had a different hearing. And at we addressed the digital discovery review. Mr. Lane was here. There was a USB provided in open court, and the August 9 order and notice of hearing identifies a change to that August 5 order. Specifically in paragraph 4, prison break investigations. By and through investigator Billy Lane shall take possession and custody of the USB jump drive, which contains the state digital evidence, tendered in open court on August 9, 2024, and shall provide same to Major Malik X. Muhammad at the Orange County Jail today, August 9. Paragraph 6, prison break investigation shall file with the court a notice reflecting that the discovery in the USB jump drive, which contains the state digital evidence, was provided to Major Malik X. Muhammad at the Orange County Jail, including the date and time of the transfer. Such a notice was provided by Mr. Lane and filed in the court file. It was discussed at that August 9 hearing as to the revising of the digital evidence schedule. Paragraph 8 states that on August 14th, 2024, 1:30 p.m. a hearing will be held, courtroom 12A, regarding defendant's review of the USB jump drive, which contains the state's digital evidence, the defendant's August 7th letter to the court, provided to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024. The pertinent case law is attached. On August 14th, we had a hearing, we discussed that, and we identified that she had the deadline until August 23rd to make any objections. Now, under the original scheduling order, which set this matters, which on August 5, which set the schedule for when there would be deadlines for objections, those would be extended by good cause shown. Are you seeking at this point in time to extend the deadline for a period for objections which has since expired?
Yes.
Okay. State?
No.
Okay. How much time would you like, sir, in order to review the state's digital evidence that it seeks to admit into evidence and tender any objections?
Well, I've got to go buy a jump drive. I've got to take it down to his office. He's going to give me that evidence. Obviously, I need to review it with my client. I've got a flight out of here around, I think, 4 o'clock. I don't know if I can get it done by then, but I don't see the necessity of an issue, maybe a week prior to trial. Whatever that is, a week prior to that Monday, October the 7th, the week prior.
State?
I'm amenable to setting a status hearing that week.
Here's what we're going to do. We'll address any objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right. Anything else?
Wow. That's late.
Give me 1 minute.
Sure.
Okay, we're going to recap what just happened here.
State, anything else?
Not at this time, Your Honor.
Madam Clerk's going to work dutifully to, it's already done?
It's already done.
Excellent. I'll have Ms. Barrios, my judicial assistant, forward these to JCS and see if we can coordinate a hearing. State will have till close of business September 10th to file responses to motion for statement of particulars and motion for additional discovery. Parties having no other business before the court. You'll have a fabulous day.
Thank you, Judge.
Thanks, sir.
Can I have a word with Sarah?
Absolutely.
All right, so they're done. The word they have with Sarah Boone, it's just saying hi. It's me again. Anyway, they're done now. Here's what happened. Lawyer shows up in court. Mr. Owens, great guy. Okay, first of all, he's doing this pro bono. That means he is working for free. He's not going to be paid by the state. He's not going to be paid by Sarah Boone. He's not going to be asking for money at the end of all this. He's working for free, and this is a tough case to sign on to. He's coming onto the case basically a little over a month before it goes to trial. October 7th is the trial date, and the judge has said, I'm holding that date. I don't care you just joined. Okay, she knew that was the date. That was the deal. That is not a reason to ask for a delay. There have been plenty of lawyers who've worked this case before you. You can pick up where they left off, and you don't need more time. So all his requests for more time were pretty much dismissed, except for a couple things. There are some deadlines where he has to file a deadline for a notice for Well, first of all, this one was not pushed out. A notice to use the battered wife defense, he has to use 30 days before trial. He has to provide notice to the state that that's what they're going to do so that they can have their own expert to counter that. He still has to do that before like a week from yesterday. Like a week from yesterday is the final day he has to file that, and I'm pretty sure they're going to go with that. That just means his expert has to be ready in the next week to say, yes, I've looked at this case and I'm prepared to say, yes, this is a battered spouse situation. That's pretty quick. So they're gonna be pushing it to get that happen. If they can't get that in, I don't know what defense they're going to run with. There's very little else that she has available to her. This is not a self-defense case, a traditional style. That if they don't get the battered spouse in time, they can't run with that either. And pretty much they just have to throw themselves on the mercy of the court and say it wasn't intentional. And that is not a legal argument I think any lawyer can make in good faith. So this is their only chance. This is their only chance. They have to go with this. They need somebody who sign up and say, yes, I can state that this is what it is. We're going to provide a defense in the next month. It's going to happen. Anyway, so that's got to happen in the next week. The one date that was pushed out, that there was a date that I believe he missed, and they're asking for that to be moved forward. It's going to be moved to the 27th of September. That is the date that he has to file any objections to any of the evidence that's going to be used against Sarah Boone. So this would be the statements she made to police at the scene, the interview, the interrogation video. He's going to be objecting to everything he possibly can on that front to try to get the pile, the mountain, the suitcase full of evidence is what we have actually against Sarah Boone, prevented from being brought into court so the jury doesn't hear that. That would be, it's much easier to prevent a problem than try to fix it after it's occurred, especially if it's in the minds of the jury. You're trying to remove something from their head. It's like, never mind, don't pay attention to that. That's tough. But if you can keep it out, that would be much better for his case. So Sarah Boone is back in chains. She's handcuffed again, belly chains. So because she's pro se, she no longer has that responsibility to take notes and everything else. So she's only had that 1 day of freedom, so to speak. Although she'll probably be out of handcuffs during the trial, even if she was wearing a stun thing. Mr. Owens has his work cut out for him. He still has not gone through everything. Sarah Boone has not gone through everything that she has. I don't know if she's going to keep all the hard copies or if he's just going to take digital copies. He's just getting some of the evidence today. Like he's headed down the hall probably right now with a thumb drive, trying to get a copy of everything that the state has against Sarah Boone they're going to use on him. So he has a ton of work to do. He also has other clients, and he lives and practices law 6.5 hours away. So he did get permission from the court to appear via Zoom for some of the other hearings. So he's not going to be, there in person for everything. He will be there for court. But Sarah Boone, she won the jackpot with that ad. I don't know how or why it spoke to this lawyer the way it did, but he's like, sign me up. I'll take this on and I'll do it for free. And that's pretty much that was the offered pay. It was just for, you can add this to your resume, I think is what he gets to do. I've been looking at the bench jumper trial. I think they have jury selection right now. That's out of Las Vegas, I believe. I think that'll be fairly short, isn't it? Isn't the trial for the bench jumping, or is it the trial for something else? Send him some Mountain Dew. He'll be good. Sarah did the shirt pro bono for you. You're welcome. Yes, I didn't bring the shirt on vacation with me. I didn't realize I was supposed to be advertising over here. Is that really how he came to represent her? Lisa, yes. In his letter to the court, where he basically says, hey, I'm the new counsel. Hello, introduction. He says, I saw her ad. I saw the Sarah Boone Seeks Attorney ad, and I said, that's me. And he met with her several times and said, I'm going to do this, and I'll do it for free. If it wasn't just the ad, it was you. You promoted her ad a lot. Well, I'd love it if you saw the ad on our channel. I think it's better that she has an attorney. I think the process is better because watching someone get railroaded by a system they don't understand is not fun. unless it's Daryl Brooks. It's just not. I don't enjoy that. I don't like people, trying and being thwarted by rules that they don't understand or know. That's not cool. Although sometimes a good pro se defendant has it coming to him, and I think it's justice is well served. I think in this case, she's up for murder. I think her having a lawyer is in the best interest of justice in this, and so mad props to Mr. Owens for standing up for this. Can he quit? Can she fire? Since there's been no hiring. He says, I have been retained. Typically, that's the term you use when you're hired, but he was hired at a rate of apparently $0 for the case. So he has been retained. I think that means he can quit because he's not court appointed, but he has to file a motion with the court to say, this is why I'm quitting. The courts don't like lawyers to just leave cases like this. So I don't think I think he's in for the long haul. Plus, there's not much time for Sarah Boone to really, get angry and get letters off to the judge. It's being paid in publicity, possibly, but I mean, who are you advertising to? What clientele are you reaching in this DMB? Are you reaching all the pro se people who are very difficult, saying, "Hey, here's your guy"? I mean, you're asking for headaches for the rest of your career if this is your poster ad for your law firm. She gave him the obligatory $1 bill or a promissory note, I think. Yeah, $1. He thinks he's the next Jose Baez. Is she the next Casey Anthony, though? Attorney's incredibly experienced, says Tara. He was even an elected head public defender for several years. He's good. I don't doubt it. He's really good. When the judge cited his credentials, said, "Look, I've done some research into you as well. You've tried over 100 cases to verdict. Okay, you are not a spring chicken when it comes to the court scene. You know how this process goes. So I think she's going to be well served by this lawyer. That's not a problem. 100 cases to verdict that's a ton. That is a ton of cases." He's been a lawyer. He's been barred, since 1986 or something like that? Good stuff. All right, we have a couple things coming up on the schedule. Let me see what we have here. Carly Gregg is set for a week out for jury selection. That is a 14-year-old child charged with murder and attempted murder. Let's see. We've got the jury selection today right now in Las Vegas for, is it Deborah or Deborah? Deobra Redden? I don't know how to say that name. I don't know why. You guys, can somebody spell it out for me phonetically? Jury selection, that's for attempted murder. He's facing 9 charges. To a verdict. Yeah, they might have all been guilty verdicts, but he tried them to 100 cases. Someone had asked earlier about Sarah Boone, saying she's just looking at this and saying, "Hey, I can make money selling this story for a movie." Florida, as far as I understand, still has what they call a son of Sam law, which allows the court to confiscate revenue earned from writing about your crime. Now, that usually goes to the fines that you have accrued from court, the fine that was judged against you, as well as to compensation that's paid back to victims. So they have that law, but the Supreme Court and the Supreme Court in many states has said, "Yeah, I'm not so sure. First Amendment, that's a pretty strong wording." So there are some states that have sort of struck that down a little bit. I know as far back as 2007, the Florida was sort of enforcing that, but I'm not sure if they've changed that since then. Oh no, Alita, your son missed singing happy birthday today. Happy birthday to your son, Alita. Happy birthday. Let's see, I sent you a text about a small case with jury selection going on for trial tomorrow. Josh, you find some doozies of cases. Let's see which ones you sent. see. Oh, Judge Brantley Clark. Why does Judge Clark always have drug cases? Is that like his bailiwick? Is that the right term? The bailiwick? It's always drug possession. Josh, welcome to the gallery. I love that yellow courthouse. Thank you. Thank you. Medical Mischief, welcome. Thanks for clicking the subscribe button. The drug case, I believe, was fentanyl. Let's see. Casey Anthony was told she could not make money. The law was pretty standard for a while. The Son of Sam law, that was pretty popular, but it's been struck down or limited in some ways. There are times that the court says, you can't take all the money they get from writing books. There's only a certain class of or certain group of money of topics and things that you can take some money from, and I believe that they keep some of the even under the Son of Sam laws, the inmate would still get a percentage of what was left. Elizabeth, we just covered Sarah Boone so far today. We're going to cover some more here in a bit, but let's jump over to, let's see. Judge Boyd is live. Let me see who else is live right now. Oops. I don't know what I just did, but I think I just, there. Started watching a movie on Apple TV, and I didn't want that. The jury selection we're talking about for Judge Brantley Clark is happening right now. Let's pop in and see what that looks like really quickly.
More, I would appreciate it. Yes. I know Mr. Frazier would too.
Oh, on what do you?
I'll bring you a different.
And she doesn't have to do that, but she's doing that basically as a friend of the court.
Right.
All right, we'll pick Mr. Warrender next. We'll bring him out after Mr. Frazier's out. Are we going on the information that was originally filed?
We're going to file an amended information this morning. It's the trafficking of fentanyl and possession of cocaine.
Okay. I'm
so
glad
fentanyl
you got rid of
and cocaine.
Possession of paraphernalia.
Got rid of paraphernalia.
I think I'd rather read any instruction than possession of paraphernalia.
It is a lengthy one.
For a first-degree misdemeanor.
And Your Honor, may I be excused?
Yes, ma'am. Thank you. Okay, thank you for providing those clothes.
No problem.
All right, I am going to take just a short break. Mr. Sullivan, you need to, and then as soon as we'll bring Mr. Warner in, we'll arraign him on the amended information. I'm assuming there's no objection to it.
So I think that court case starts tomorrow. Did you get the link? Sovset contempt hearing. Mathis, let me look. Where did you send it, Mathis? Was it to email or a text message? Yeah, I keep saying it's Monday. It is not. It is Tuesday. I apologize. Erica, welcome. Welcome. Good to have you here. Where do we submit sound bites again? Let me give you the link really quickly. It's a file called WeTransfer. Let's see. Actually, if you send them to, let's see, can I let you guys do that? Transfers. Math, just got the link from you. Just one second. Mathis, that one's not a clean feed that I can use. It's not a court feed. It's another user's content. Need a court feed, unfortunately. Okay. Here's the link really quickly, if I can paste it. That's where you can send files, whether it's video or audio. If you've got like an audio byte that you need to send, I can get it. Watching, always watching. That's a good sound bite. Let's see. WeTransfer is how it goes. It's actually a fun little tool. It's pretty clean cut and very quick. How much longer are you staying here? We'll be gone, well, Thursday. I'm not sure if we leave Thursday or Friday. We're out of here. So just a couple more days here. Which is good. I think Mrs. R.A. is getting my suit dry cleaned, which is awesome. Mrs. R.A. feeling better? Yeah, everyone had like one day or two of just feeling a little under the weather, and everyone's back to normal. Except for me. I felt fine the whole time. Probably because I don't go anywhere and don't get any germs that way. Let's see. Let's see if we can pop into Judge Boyd while we wait just a moment here. Chancery's up as well. Let's see what he's doing. Let me check with Judge Wolf really quickly. Judge Wolf is one of the busiest judges in the country, but he's good. Oh, he's really good. Court is now in session. Please be seated. It looks like he's in a good mood this morning, too.
All right, good morning. We'll start with the call of the docket.
2019 CB 95, Eddie Birdside Jr. versus Sarah Wing.
Good morning, Your Honor.
Good morning.
I'm here for the defendant, and that is our motion for a Rule 16 conference or for a scheduling order. We've actually come to an agreement on a scheduling order, so I've got that to pass up to the court.
Good to hear. We'll pass that to the Bible, please. Let her hand you that.
And I've got some copies with it if I could get those stamped.
Can you please validate my parking while I'm here? This is the great state of Tennessee. Great state of Tennessee. Judge Wolf, just a phenomenal judge.
I signed the original. You can get a copy, a photocopy from the clerk.
Thank you.
22 CB 9, David Stanridge versus the Property Place.
David Stanridge versus the Property Place. I think we've seen that lawyer
I
before.
represent the defendant on that case too. That's a motion for to compel supplemental discovery responses and for a scheduling order. We received some supplemental discovery responses on Friday, but we haven't been able to look at them to see if they're sufficient. But we've got an agreed order on that one as well. And same with the scheduling order, an agreed order on that.
Okay, judge signs stamps. Good to go. This is quick. We're flying through these
That's from last Friday.
cases.
You can ignore that little note.
He has surgery this week on his shoulder,
Also,
I
Moyer
believe.
put a note up there
And he'll be out for a
last
couple
Friday.
weeks. Pretty serious surgery on the shoulder. It takes a couple weeks for recovery.
All right, I have signed your orders.
Thank you, Your Honor.
You.
Look at that. The attorney sets his hat on the table. He's got
We
a
have
big
an
old
agreed order
cowboy
that
hat.
I've already signed it.
CD31, John Trotter versus Payne,
Same lawyer. Just stay up there.
You might as well just,
I didn't
you
realize.
might as well just, unless you need the exercise, you can just stand there until
well,
we
I
finish
do.
the docket call.
Your Honor, I'm actually here for Attorney Rhonda Crabtree-Myers. This is her motion to compel. I've got a proposed order. I don't know if the defendant, Donald Patton.
Hangwangle Investments et al. Donald
Hangwangle.
Patton. No one's here.
So what do you want?
It grants 15 days.
That was her proposal, Your Honor, yes.
All right, thank you. I'll sign that order.
Thank you.
LLC versus Stonegate Home LLC.
Ooh, two companies suing each other. Two LLCs going at it.
Good morning, Your Honor.
Good morning.
Charles Gilbreth for Green Rise.
All right, your second motion for default judgment, if I'm understanding correctly.
Yes, Your Honor.
Now, let me suggest to you that, first and foremost, I'm not trying to avoid hearing this, but this was originally heard by Judge Lockhart Mash back in January, and then she heard the motion to set aside the default judgment that was entered, according to my review of the file, in July, and she entered an order at that point in time. And what my understanding is that the defendant was given until August the 7th to file an actual answer in the case. Is that correct?
Yes, Your Honor, that's correct.
And then September the 3rd is the date of the filing of the actual answer. So your motion is based upon two things, if I'm understanding correctly, and I want to give you an opportunity to be heard. One is that, number one, it was a sworn account and there was no sworn denial filed in the answer. Second is that even if I consider the answer, it's substantially later than what Judge Lockhart Mash awarded them as an additional time for filing an answer.
Yes, Your Honor, that's correct. With one exception, the answer was filed along with the response on August 30th.
30th, I'm sorry. Okay.
Look at this. 20
Okay.
months,
We'll go ahead
and
Let me hear from you if there's anything else that you need to add.
There's not much more, Your Honor. You just went through the chronology of how we've gotten here. You know, the case has been around for almost a year now, and it's part because of some failings in our opinion on responses, and on some other instances because of this court's procedural machinations, which is perfectly fine, but it's drawn on, and you know, everything stems from this last word where they had until the 7th to respond. You know, there was no forbearance entered, they didn't do it. We waited around on August 22nd, we filed our motion, no response came until the 30th, and then that's when we got the sworn answer. Now, in Stonegate's response, they put forth two arguments, basically. One, they say we don't have standing to bring these claims, period. And two, that there's a forbearance that everybody had agreed to. Well, the standing argument, you know, I can't speak to that here, Your Honor. We have a complaint on sworn account saying there was a merger and this is why we can bring our claims. If they don't think that's the case, they should have filed a motion to dismiss and given people proper time to go address those arguments. It's not proper to bring that on the Friday before a Tuesday hearing to assert standing. As to the second argument, the forbearance, as Your Honor noted in our reply brief, it's just the timeline order of events that are put forth by Stonegate just aren't correct. We filed our motion. We immediately.
We're gonna jump to another court that we haven't been to in a while, mostly because this attorney is out of sight.
You understand that upon conviction, you face a fine of up to $10,000, 3.5 years of incarceration, or both.
Hallelujah.
And do you understand that there's a recommendation here for 2 years of probation? But I don't have to follow that. Do you understand that?
Yes, I do.
I could sentence you all the way up to that maximum possible penalty if I thought it was warranted. Do you understand that?
I do.
Do you still wish to proceed and enter a guilty plea?
I do, yeah.
Did you go over that criminal complaint with your attorney? And in particular, the section that basically says what happened that day and why you were charged with the crimes?
Yeah.
For the most part, are those facts accurate?
Yes, you are.
And so you're admitting here today that you in fact did possess methamphetamine?
Yes, I did.
All right. Ms. Erdman, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Do you have any questions for the court or for your attorney before I proceed?
No.
Has anyone made any threats or any promises to you?
No.
So you're just pleading guilty voluntarily and fully understanding what you're doing here today?
Well, it's the law. You cannot possess methamphetamine, so.
I wish I had more people like you in front of me. I'm going to tell you.
But I don't think it's a right to tell anybody what they can and can't put in their body. That I disagree with.
That's for the legislature to determine,
I understand,
to decide, and the courts are just to enforce it, and you understand that. And so you understand that even though this court didn't set the law, that the law is there, and and you broke the law.
Yep.
All right.
So, yep,
and so
had meth. Thank you, Dallas Board, Boston Bread.
No one's made any threats. No one's made any promises, but you're pleading guilty today because you're accepting the responsibility.
Yep.
Are you satisfied with your attorney's services? Has she done a good job?
I'd say I didn't get anything in the mail on what they were offering me. You know, it was pretty sudden, but I'm gonna accept it.
Okay.
That plea.
All right. And so you just want to proceed here today and accept probation, correct?
Yeah. I haven't been in trouble. I think I've over 20 years now. I think since my last my OWI was.
I think that's great. I mean, you're accepting the responsibility and you're saying I did it and you understand the consequences. So as to count one, possession of methamphetamine, how do you wish to plead?
This guy in the white shirt.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of possession of methamphetamine. The other count will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Renicky.
Your Honor, this is a gentleman that normally would be aging out of the criminal justice process. I don't know, but I suspect there may be some AODA issues. And so we would ask for a withheld sentence and 2 years of probation with the usual AODA type conditions, no use or possession of any illegal drugs or drugs without a prescription or paraphernalia, an AODA assessment and follow recommendations, and then the usual DNA sample surcharge and court costs and fees. Thank you.
Okay, thank you. Ms. Erdman.
Thank you, Your Honor. Somewhat to Mr. Brenner's point, I kind of wish there was a point where we could say, in the legal system generally, this person's, of an age where they're making their own decisions and they're an adult, but obviously we can't do that. That's not our position here today. And so I think Mr. Brenner is a very open and candid individual. I think he's a very responsible individual. And I think he does deserve, the opportunity to demonstrate that to the court in whatever way the court feels is appropriate. We do, I believe, have all of the factors that Your Honor needs to cover. We've considered them, and as Attorney Renicky points out, if there are needs, they can certainly be addressed, and on probation would be the best way.
All right, thank you. Mr. Brenner, anything else that you want me to know?
No, please feel good.
Okay. All right. Well, it's hard to argue with you, Mr. Brenner. You understand the severity of the case. You understand the crime. You understand that you violated it. You're admitting You're admitting responsibility for it, and you're wanting to be accountable. You may not agree with the law, but you understand you're not, nor am I, or anyone in this room is in control of what laws are in our country. Just the fact that we have to follow them, or there could be consequences. I don't think you're a menace to society. I don't think you're a risk or a safety hazard or anything of that nature. I think that you are a man who understands himself and understands his life and understands what he can and cannot put in his body, either legally or in what your body can handle or control. It is what it is, and yet you understand what you did that night, and hopefully you're not going to be around methamphetamine, or you're not going to engage in that. That is not something that I want to see you go down that path. I can't say anything about the marijuana, the
next
THC.
Year. Okay, next year.
Go to Minnesota, go to Michigan.
My family's in Minnesota.
Yep, go there.
I don't want to live in Minnesota. I like Wisconsin.
Well,
I like people over here. I like where I live.
Unfortunately, Wisconsin doesn't allow THC use. You can use the legal things that they have with the Delta.
They got legal meth. You're coming out with?
Well, I don't want to know about that. I hope not to. But hopefully probation will just be there and help you out, and it's going to be something that can guide you. I'll follow the recommendation. I'm only going to put you on probation for 1 year, 1 year of probation with a withheld sentence.
No, thank you.
Conditions are going to be absolute sobriety. There's no use or possession of illegal drugs, substances, or paraphernalia.
Okay.
And that's because we are in Wisconsin, and even if you had a medical prescription for substances in Wisconsin, we have to say no. So absolute sobriety, no bars, no casinos, no liquor stores.
I work in a bar. I work for the poorhouse.
You can work for the poorhouse, but you just can't drink there.
I quit drinking.
So you can, except for employment purposes. So no bars, no liquor stores, no taverns, except for employment purposes.
Groundskeeper and floor maintenance.
Excellent. Well, that's good, and this won't interfere with your ability to continue to work there. Gainful employment, you're doing that, so that's all good. I'm going to have you provide your DNA to the sheriff's department. You'll go follow the path and go to the sheriff's department.
There you got my DNA.
You just have to double check.
I got to do it again?
I have to order it with each and every conviction.
It could be an imposter.
You could be. And
Right.
So go provide your DNA. Once you do that, go report to probation. It's kind of kitty corner from the building here across the highway. Get that all set up, and then you should be good to go. Okay. 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I'm going to only order $350 in DNA surcharge and court costs. I'm going to waive the rest. You have $350 posted, so you should be good to go with that. You don't have to owe anything else. I think the punishment of a felony, no use or possession of a firearm for life, or voting in any election until your civil rights is restored. Your civil rights are restored. I think that's punishment enough. You're accepting responsibility. So I'll waive the other court costs and fees, okay? So what you're going to need to do is come up here, get the form for your DNA, go down to the sheriff's department, provide that, then go report to probation immediately, okay?
You want me to report today?
Yes, please. Anything I'm missing, Mr. Renique?
Just any programming per the department?
Yep, and any programming per the department. You're still on Johnson Street?
Yes.
Telephone ends in 2747?
Yes.
All right, we're good to go. Come get your paper, go down to the sheriff's department, then head to probation.
Thank you, guys.
Thank you. We are adjourned. Yes.
I don't think we need to go on the record, but I'm not quite sure what you want me to do about this. Mr. Scheuer went down to the jail, and they tell him they can't take his fingerprints or DNA because their equipment is not working. And they're telling him he needs to go to Polk County to do that. I don't think he needs to go to Polk County, and he doesn't have a car.
I'll just give you 2 weeks to do it.
If they tell you they can't do it in 2 weeks, get it in writing.
So I'm guessing their machine is broke. So I'm not going to send you right now. If it's broke, I believe Mr. Chapman. So you have 2 weeks to come and give your DNA to the sheriff's department. Okay.
Remember,
so you should be good to go. All right. Thank you. So just head to probation.
The buccal swab is broken today.
Thank you.
I love this court. this judge, her empathy for especially people on their path to sobriety is unbelievable.
Mr. Keene?
If you watch her holding drug court, it is absolutely amazing.
Why do I have Mr. Keene on? And
I think the fingerprint machine and the DNA machine is also made by the guys who make the McDonald's ice cream machine.
Mr. Zuber, what do I have you for today?
Good morning, Judge.
Good morning.
In a short time ago, Mitchell Matson, 24 CF 157.
Did Mitchell hire him or okay?
I noticed a retainer this morning, so.
That's fine. Okay. Otherwise, I was going to court appoint Daniel Chapman, but Zuber's fine. Zuber's great, actually. I mean, they're both great. So you can come on up and we can do your case.
Off the record, Judge, my client relieves court-appointed counsel, so that obligation, I assume you'll waive.
What?
I'm sorry, I missed the first part.
Mr. Matson hired me yesterday, and I opted in this morning, and I know you ordered.
Oh, yeah. And so it's not going to be court appointed. It could be either. I don't care. I would have no problem appointing you, but if he's already retained you, I'm all good to go either way.
Right, but you had ordered him to pay a certain amount.
Oh, yeah, that would be waived, definitely, if it's not going to be court appointed.
Right, and this is a private pay, so not a court appointment. So just to make that clear.
Who's the Galactic Defense for?
We will go on the
doing
record in the matter 24 CF 157, 24 TR 679, 680, 681, State of Wisconsin versus Mitchell Matson. The state appears through District Attorney James Renicky in person. Mr. Matson appears in person with counsel Stephen Zuber appearing by video conferencing. We're set today in these matters for initial appearances and status conferences. Mr. Matson did apply for a court-appointed attorney. However, he has privately retained Mr. Zuber. And so all issues related to the court-appointed process are now vacated. He does not need to pay any deposit, etc. Mr. Zuber, were you able to go over the criminal complaint with Mr. Matson?
I have, Judge. We've waived reading thereof, and I believe there are four misdemeanor counts and or pleas of not guilty to those. In regards to counts 1, 2, and that's all I'm saying for felonies. We'd waive the time limit for preliminary hearing and ask for a preliminary hearing down the road, approximately 8 weeks.
All right. Not guilty pleas will be entered on your behalf as it relates to the misdemeanors. You do understand all counts and charges, is that correct?
Yes.
And your address is still in Robbie Road?
Yes.
Telephone ends in 1371?
Yes.
Maybe send you text message notifications of upcoming hearing dates?
What was that number again?
1371.
No, it's.
Want a different number?
It's
867-5309. It's 867-5309.
Hearing, your attorney is asking that it be approximately 2 months down the road and waiving time limits.
That attorney is chomping on some gum.
I could do November 2nd at 2 in front of Commissioner.
November 2nd, I think, is a Saturday.
No, I'm sorry, November 7th.
Oh.
At 2.
He's like, I don't do court on Saturdays, Judge.
All right. All right, November 7th at 2 with Commissioner.
Judge, we'd ask that there's 3 trailing TRs. I did not opt in, but they're trailing for now. 24 TR 679, 680, and 681. Could those trail?
Yep, they'll track along.
And who's the court commissioner? I'm sorry.
Commissioner Krupa.
Thank you, Judge.
All right, anything further?
Nothing further. We'd ask that bail continue.
Bond and bail will continue. Thank you. We are adjourned.
Thank you, Judge.
Anna Martin.
I'm waiting for Kathy Malsom to
Just
step
have
up
a seat.
with her attorney.
We will go on the record in the matter 24 CF 159, State of Wisconsin versus Anna Martin. The state appears through District Attorney James Renicky in person. Ms. Martin appears in person with counsel Glenn Keene, appearing by video conferencing. We're set here today in this matter for an initial appearance. Mr. Keene, were you able to go over the criminal complaint with Ms. Martin?
Yes, I have, and we would waive a further reading, and we'd like to waive a preliminary hearing and set it for status.
Totally waive a preliminary hearing today?
Yes.
She's
all right.
Court reporter?
So you understand those charges and the maximum penalties? Yes? You're going to have to speak in the microphone. Ms. Malsom over there on the video conferencing, she's a court reporter and she takes everything down and she has to hear what you're saying.
And she's
so if
way
you
out
want to
by
just
the
pull
moon.
that microphone
So you
to
have
you
to talk
and so
loud.
you can just speak clearly, okay?
Yeah.
All right. So you understand those charges?
Yes.
And is your address still on Grouse Trail?
Yes.
Do you have a telephone number?
It's 867-5309. 5309? Yeah.
Maybe send you text message notifications?
Yep.
Okay. Now, again, I'm going to have you pull the microphone really, really close because I'm going to have to ask you a whole bunch of questions, okay? So did your attorney go over with you what it is to have what's called that preliminary hearing?
Yes.
And so the burden is on the state to prove a felony was probably committed and probably committed by you. Do you understand that?
Yes.
And by waiving your right to a preliminary hearing, that means you're agreeing that the state can, at minimum, meet that burden. Do you understand that?
Yes.
Now, how old are you?
21.
Can you read, write, and understand the English language?
Yes.
Any drugs, alcohol, or other medications today?
Yes, please. Oh, wait,
Do you
no,
understand
no.
at that preliminary hearing, your attorney would have the ability to ask questions of the state's witnesses or call witnesses to testify for you. He would also be able to produce evidence on your behalf or possibly discover things about your case, which could include defenses. Do you understand those things that you're giving up here today and it's only for this hearing?
Yes.
Do you understand that if the state does not meet its burden as to that felony, I could reduce the charge to a misdemeanor or dismiss it altogether, but you're giving up that right today?
Yes.
And do you understand that once you give up the right to this preliminary hearing, it's forever and you can't get it back?
Forever.
Yes.
Has anyone made any threats or any promises to you for you to plead or for you to waive your right to a preliminary hearing?
No.
You're doing so freely and intelligently. That means you're telling me you fully understand what you're doing here today?
Yeah.
And voluntarily?
Yes.
All right. I will find you are competent. You're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and find the matter over. Information, Mr. Renicky.
I'll have my staff prepare and it'll be electronically signed and filed today and it will mirror the complaint.
Would you like to do the arraignment here today, Mr. Keene, or set for another date?
Today would be fine, Your Honor.
So again, they're the same charges. And so you understand those charges and those maximum penalties, Ms. Martin?
Yes.
And do you need me to read them out loud to you or are you telling me you understand them?
I understand.
All right. Not guilty pleas will be entered on your behalf. You are entitled to a jury trial and you would be entitled to a speedy trial should you request one. What I can do is set you for October 31st.
Oh,
Does that
should
work,
you
Mr.
request
Keene,
one?
in the morning, October 31st?
I thought she said something else.
Yes, Your Honor.
I could do 10:30. Does that work?
Yes. I'm adding
All right.
or no.
October 31st at 10:30. October 31st at 10:30, we'll have what's called a status, and you'll update the court to let me know if there's been a resolution or where we're going with the case. Okay, Ms. Martin?
Okay.
All right. Thank you. Bond continues. We are adjourned. I've got a notice for you. Mr. Chapman, and there you go. Ms. Bearhart. We will go on the record in the matter 24 CT59, State of Wisconsin versus Randy.
Hang on. Hello? Mary?
Hello.
Hello?
Hi, this is Mary from Med Health Center.
Mary,
I'm
how
calling
are
to
you
let you
doing?
know that after this recent open enrollment, if you have Medicare Part A and B, you're eligible for great newly added benefits like monthly $180 cash back, dental, hearing, vision, prescription coverages, and food card at absolutely no cost. So, do you have Medicare Part A and B?
I don't think so. Hello? Mary? What is the right answer? How do you get past the bot in this? This game is so hard. This game is so hard.
31st, Judge?
Yes. Can you do 1045?
Yes.
I'm in day 2 of a trial that day, Judge. It might not go, but it might.
I don't like saying yes to
Let's see about
recordings
something else.
because they record your yes and then they might send you something you didn't want.
How about October 2nd at 11?
That looks just fine.
October 2nd at 11 o'clock, we will have a status conference. You can get your notice and you're free to go. Thank you.
Thank you.
Mr. Berg.
Tag 20 months. Thank you, Tag. It's been great. Beeps. I have to say.
We will go on the record in the matter 23 CF 172, State of Wisconsin versus Joseph Berg. The state appears through District Attorney James Renicky in person. Mr. Berg appears in person with counsel Daniel Chapman. We're set today in this matter for a status conference. Mr. Chapman, please update the court.
Judge, I believe I have all of the discovery in this case. I have a copy of an offer that was previously sent to the previous counsel, and assuming that's still the offer, I emailed a counteroffer or discussion to Mr. Renicky, and I haven't received a response yet. I guess I just asked for another status date on that.
Mr. Renicky's like, I got an email.
Mr. Renicky, did you receive the counteroffer?
I'll have to double check. I don't immediately notice it, but I'll double check it when I get a minute.
All right, this is going to be the last status. Well, you're new on this case, aren't you?
Yeah, I was just appointed July 15th, Judge, but.
October 2nd at 11. October 2nd at 11.
One more status here. Big yawn. Sorry about that. The NASA lady's the court
All right,
reporter.
bond
They've hired her
continues.
from
We are adjourned.
Galactic Court Reporter
Shannon?
Force.
There you go.
You say yes, and then they put someone on.
We
they'll
will
try to
go
scam
on the
you.
record in the matter 24 CF72, 24 CF 190, State of Wisconsin versus Stacy Shannon. The state appears through District Attorney James Renicky in person. Ms. Shannon appears in person with counsel Daniel Chapman. We're set here today in these matters for an initial appearance and a status. Mr. Chapman, you are not yet appointed to the newest case. Are
I
you
didn't know
aware
there
of
was
it?
a newest case, Judge.
A newest case as of August 23rd, 2024, with 1 count of possession of methamphetamine, 1 count of felony bail jump, 1 count of possession of drug paraphernalia. A criminal complaint has now been served upon defense.
It just got handed to him.
We do need
literally.
her to sign her new bond.
It's like,
I
and
believe
there's
we
another
still
case.
do, and so we'll get that printed so she can sign it.
Talk.
I was going to jump to a Kansas court, but they just barely took a break for.
All Are you able to do the initial appearance here today, Mr. Chapman?
I would prefer to be able to read the probable cause section and discuss it with Ms. Shannon, especially since I don't actually represent her on this case yet. I hate to waive any rights on that. So could we schedule this initial appearance, Judge?
Yes, we can.
Alf. Love the Alf reference.
Wednesday, September 18th at 1:15.
That would be fine.
All right,
Does that work for you?
Wednesday, September 18th at 1:15, we will have an adjourned initial appearance.
And Ms. Shannon will have to speak to the public defender. I'm appointed by them, but she'll need to request an additional lawyer. They will probably appoint me, but
All right,
she has
so
to go through the motions.
you just need to reapply for this case, call the public defender's office and give them a call, okay? You can come up here, look at your bond, sign your bond, and then get your notice. You're free to go. Thank you.
Thank you. I
She
think
needs some
that's my
help.
last one for 11, Judge.
I think so, and then I'll see
She
you at
picked up another
11:30.
meth charge.
All right, Ms. Molson, we need to go over to our guardianship Zoom. Okay. Thank you.
All right, they're going to bail and go to guardianship, so we're going to bail and go to Judge Wolf again.
Ms. Hitchcock, the plaintiff has rested her proof. If you wish to put on any proof, then I'm happy to let you testify. Do you want to testify?
Yes.
I'm sorry?
Yes, sir.
All right, raise your right hand. Let me place you on the road. Do you solemnly swear or affirm the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. All right, it is you are your own witness, so you can testify about any of the issues that you wish.
Okay, so this is not a case of violence. We have no record of violence on this between us. This is about a divorce. There's no arrest or paperwork showing this. Past that, when we went to and moved back to Tennessee for me to take over the trailer, I had no idea the trailer's been flooded at this point. Still don't know that till now. I turned off the water. Me and Sam ourselves turned off the water before it was locked up. She gave me the title herself because I paid for the trailer in cash before we got married. It's her parents' land. The agreement was I got the trailer, she got the land. I was willing to move the trailer. Then she went to court and started fighting for it. That's when she got marked and she wanted half of it. That's why it's not been sold yet. We're waiting for this decision to move forward and sell it. I've never even known about the water in the trailer, how it happened, because the water was turned off from the city.
All right, so what are you suggesting? What are you asking? She's asking to be awarded the trailer so she can have it removed and believes that the cost of removal will be equal to what it's worth.
I don't believe she's trying to remove it. I think she's trying to live in it. If she wants to remove it herself, we can sell it and divide take the cost. I'm just trying to get rid of the trailer, but she put us in court to not even get rid of it yet. So I can't get rid of it while we're in court. That's why it hasn't been removed yet.
All right, well,
she's fighting for it, in other words.
Understand my question. She's asking to just be awarded the trailer so she can have it removed. Apparently thinks there's no value to it.
That's
what
fine.
are you asking to do?
I can remove it myself. I can literally hire to get it sold.
All right. Do you have
That's
anything?
what I wanted. It awarded to me and then she awarded the land. And I'll get it done as soon as it's done.
Well, apparently the land was never transferred into either of your names, so there's no land to award.
Right. That's my point. That her parents have the land. I would take care of it.
I'm finished talking before you began talking, please. There's no land according to the testimony in this case, so there's nothing to award in the way of land. The only asset that I'm told is this trailer.
Right.
And she says it has no real value other than the cost of removal. Mr. Odle, you may address the witness in cross-examination if you wish.
So, Mr. Hitchcock, how long have you been back in Arizona?
Well, I've lived here with Sam before Sam went back to Tennessee, so 2 years.
Okay, so you've been in Arizona for 2 years, right?
I drove back to Tennessee to get the title, get the keys, and lock the trailer with the water off, and then went back to Arizona, yes.
Okay, so my question though is you haven't been in Tennessee for 2 years?
No, a year. I went to get the title in the trailer and lock it, and to turn off the water, we closed it all down, and I left.
And
so I'm not sure how the water's there.
So when was it that you left Tennessee and went back to Arizona?
July of last year, 2023, when we gave So when she gave me the title and the keys, and I locked it when the water was off.
And for 6 months, you didn't do anything to sell the trailer, did you?
Yep, we were going through divorce with you, so I couldn't because she wants half of it, as you stated to me in the beginning.
I'll remind you that this divorce was filed December 1st, 2023. So 6 months passed and you didn't do anything to address the trailer that was sitting on property that neither you nor your wife owned.
We actually looked at moving it, but she wanted half of it, so we couldn't do anything until court settled it.
You would agree with me that the divorce was filed December 1st, 2023?
Yes. But me and her were in communication before trying to get rid of it. Yes.
Were you arrested in Arizona for domestic assault?
Yes, there was no charges, though. That was dropped instantly.
Okay, but you were arrested for an assault against
They
your wife.
take away somebody for safety of both parties. There was no charges. Yes, sir.
Okay, but you were
This
arrested.
isn't about assault. This is about just the divorce.
Well, ma'am, I'm asking you if you were arrested for...
I was arrested and released. I was not charged.
I think there were some charges that might have been dropped, maybe. Let's see.
Judge, I have no further questions.
Right. Ms. Sheila Hitchcock, do you have anything else you want to say or anything else you want to offer in the way of proof?
If you can have her prove the trailer is fully totaled, she can get rid of it. No, fine with her, fine with all that. There's no worth to it to selling it. That's fair.
Well, it's not my job to have her prove anything. There's neither of the parties have introduced any evidence of the value of this trailer other than the testimony of the original plaintiff, Ms. Samantha Jean Hitchcock, that the value of the trailer is equal to the cost of removal.
Can I ask for pictures and proof?
Okay. You haven't offered those, and I asked you if there was anything else you wanted to offer.
I would like to ask for the pictures and proof of the trailer now, the water damage and all that.
I'm sorry, what?
I would like to ask for pictures and proof of the trailer and the worth of it right now, since I haven't seen it yet or been told about this yet.
Well, I'm going to do you one better. I'm going to give you the trailer, and I'm going to give you 15 days to move it off this property. Otherwise, if you don't have it moved off the property in the next 15 days, then the title to the trailer will revert to the plaintiff, Samantha Jean Hitchcock, and she will then be responsible for removing it. If you say that it's got some value, I'm giving it to you, but you got 15 days to get it off this property. And that's the court. She's awarded an absolute divorce from the defendant on the grounds of inappropriate marital conduct. Each one of them is awarded the personal property in their possession, with the exception of the trailer. Each of them will pay their own debts. Mrs. Sheila Hitchcock is awarded the mobile home with the proviso that she must remove it from the real property owned by the plaintiff's parents within 15 days. That 15 days will begin running tomorrow, obviously, since it does not take effect until today. She'll have 15 days to remove it. If she removes it, she can sell it. It's her property. She can do with it what she wants. If within that 15 days she does not remove it, then the court orders that the title shall revert to Samantha Hitchcock, and she will then have the authority to dispose of the property as her personal property, sell it, destroy it, whatever she wishes to do.
Can it be asked that she's not allowed to live in it?
I'm sorry?
Can it be asked that she's not allowed to live in it, that she has to get rid of it as well, that she can't resell it?
I've just made a ruling. That ruling says what it says.
15 days isn't long enough for me to get that trailer moved. I'm out of state.
I understand, and that's why it's been there since 6 months, and I'll give her 30 days. That's sufficient time. 30 days to remove the trailer, and at the expiration of that 30 days, because you are in Arizona, I understand that might make it more difficult, but we'll give you 30 days to remove it and go from there.
Can I get pictures from Samantha of it before I fly in there?
I'm sorry?
Can I request pictures from Samantha and Mark before I fly in there of the trailer?
You can request anything you want to from Mr. Odell, but this hearing is concluded. Thank you.
Okay.
Wow. Wow. Spicy. I almost want to go back and see what the inappropriate marital conduct claim was, but we'll skip that one for now. Whew. Everyone take a deep breath. Judge Wolf, do you need a break? Just a couple minutes before we move on to the next one.
Next case on the docket I'm showing is Richard Allen Baker versus Jesse Abigail Baker.
Judge, I represent the mother in this case, and this is our motion for an ex parte order that was not granted, and so we put it on the docket for today. I also have a motion for the children to be interviewed in chambers, and we had subpoenaed the father to bring the children here, and that's for a hearing.
Well, so which of those motions do you want to take up first?
The ex parte motion.
All right. You want to make an opening statement in it?
Before we take any proof on that motion, in our response to the ex parte motion, which we're here today on, we included.
Sorry, there are 3 files, and I'm having to find the right one. We're on volume 2, if I see it correctly.
It's a big case.
I do recall filing quite a bit of things last year. In our response to the motion, we cited Rule 6503, where the rules of civil procedure require, prior to a ex parte motion being filed, that notice has to be given to opposing counsel, or at least notice of an intent to give notice and why it was not required. And that was not done here procedurally. And Mother made this very same argument in February of 2022. I had an ex parte motion pending before this court. I was actually granted ex parte, but on the hearing on that motion, whether or not to extend it and make it a TRO while the case was pending, Mother's former counsel made the argument under 6503 that because I did not give her notice prior to filing that the motion should be dismissed. And the judge had heard that motion. Judge Lockhart Mash granted that and dismissed the motion. So I make the same motion today. What's good for the goose is good for the gander. There was no notice given to me or an affidavit stating that an attempt was given, and therefore it does not comply with 6503 and it should be dismissed. So I wanted to address that before we get into any proof.
Judge, that Rule 65.03 specifically provides that if the court is considering to issue the temporary restraining order ex parte, then I would be required to provide the certification. Your Honor did not grant the ex parte motion. Also, in my motion, I did request that, basically, alternatively, I requested that this matter be put on the docket for a hearing. And so when Your Honor did not order the ex parte order, then I requested that it be put on the docket for a hearing. So in my mind, this is now a standard motion. It's not considered, obviously, it's not an ex parte hearing because all of us are here. So I think that this Rule 65.03, we're past that at this point.
Have you filed a petition in this case?
I have filed the original petition is on the modification. And then in
When
the
was it
interim,
filed?
I filed it in July. And then in
July.
the interim, things have occurred to where we felt the need to file the ex parte motion. On May 13th, thank you. This ex parte was filed in July. I'm sorry, Judge.
I'm just trying to locate the petition that you filed.
See if she gets her ex parte meeting. Sounds like divorce because the last name are the same but for the two parties, and we've got children involved. They're asking for an ex parte meeting, a hearing where the judge interviews the children to get some more in-depth information. Ex parte is basically a meeting without one of the parties. One of the parties is not going to be there. So you X off one of the parties and you have the meeting anyway. Could be without defense, could be without the prosecution or the plaintiff or the defendant. Keeping my eye on Thurston, Washington, courtroom 2 right now. They just started a few minutes ago. Not sure what's up, but I want to see if anything interesting happens.
I entered an order in this case in July of 2023, which concluded that.
I have a copy of my underlying petition,
Let me
Judge, if you would
finish.
like.
And that order was entered in July of 2023. There was a notice of appeal that went down and was later then dismissed. As a result of that, the appellate court ruling that there had not been a proper compliance with the orders of the rules of appellate procedure. And according to what I'm looking for, there's a order of withdrawal by the prior attorney for Mrs. Perricone now, and that has been withdrawn. I do not show that there is a petition, so I'm going to take a short recess and let the clerk and you compare files, because I don't see what I'm looking through a copy of any petition that's been filed. For your information, the court declined to sign an ex parte order, restraining order in this case, for the very reason that this is a very contested case that I've heard matters in before, and I was aware of the fact that it had gone up on appeal and had been dismissed by the appellate court, and I was not going to, without a hearing, make any modification of the custody arrangements. So if we have a hearing, it's going to be on the request for a restraining order rather than any ex parte, since both parties will be here. We'll take a short recess. Let us see if we can locate that petition.
Well, Judge Wolf goes back to chambers and tries to soothe his migraine he got from the previous trailer case. We'll jump to court
office
in Thurston, where Terry Ayers
that was probably
has a mouthful of
beginning
food.
last week.
It has not made
And
its way
he's eating more.
into
He's got the
our
Doritos.
file.
He's got the Doritos.
Yeah, because I called and contacted the attorney's office to make sure to get that filed. So I did file it, and I have another copy if I need to file another copy.
Okay, yes, we do need you to file another copy. I apologize. I don't
looked
know
like
what
Cool
happened,
Ranch.
but
That's
we
okay.
don't have it.
No problem.
Yeah, I don't see it. I don't see it in there.
All right. And then do
is
we
it
have,
I'm sorry.
go ahead.
Is it possible that I wrote the wrong number on it, since I got like 3 notices to appear that I wrote the wrong number on
It's
it?
definitely possible. So the number that you want to put on it is 4A054.
Terry's trying to swipe right.
772.
Okay, I'm not sure if I did or did not, but I want to have
Okay.
the number just in case.
Okay, so we'll
Awesome.
give you more time to get that filed. And then we have Miss Painter here on the no contact order. Is that correct? Oh,
Yeah.
Gabriella has
Victim advocate.
amazing braids.
come on forward, Miss Painter. Yes.
Terry, you're making all of us hungry.
All right. And so I have a written
Safety
motion
glasses, hard
that you're
hat,
asking
and
for an
Doritos.
exception to speak over text or email to discuss finances. You're in a lease together, responsible for utility and rent payments, need to discuss these items, and a third party exception to have someone pick up the dog and drop them off with the other party. The dog is able to be cared for in a humane, so that the dog can be cared. So the dog goes back and forth?
Yes.
Okay. And so you want to have the court, you're asking the court to approve of a third party person to transport the dog back and forth?
Yes.
Do you have a person?
Yeah, his dad would be fine.
Okay.
Terry is eating all the lunch food.
So Ryan's father.
Ryan's father would be fine.
Yes,
All
ma'am.
right. Okay. So
I would like.
before you, if you're going to testify, go ahead and raise your right hand. Swear to tell the truth and nothing but the truth. Oh, yeah. Yeah, I do. Okay. Is there anything you wanted to add to the written motion?
Yeah, I would like the no contact order rescinded altogether, if that's possible. I mean, what happened was what happened, but we haven't had any contact of any sort. He hasn't tried to reach out to me. We haven't seen each other. This is the first time this has ever happened. And I also, we added about couples therapy. I mean, me and Ryan haven't had a chance to talk, but I'm still open to making things work out and going to couples therapy if he's open to that.
Okay. And do you
She wants to get back together.
Any kind of domestic violence support? Do you have like a sponsor, or have you talked to anyone about a safety plan or anything like that?
Yes, I have. Me and the advocate have talked about that. So I do have things set into place that if something did come up that I could do.
Okay.
I do have those in place.
Okay. And if, were you residing together? If I lift the no contact order, is the plan to reside together?
That's what I would like, but that also plays a role in what he would like.
Right. And you haven't been able to talk that.
No, and we have not been able to talk at all. And I do want to say, I did play a part in what did happen that morning. There's ways that I could have de-escalated the situation as well. What happened did happen, and I could have done things differently. I just, from here going on forward, things will be done differently if it's with him or someone else. But I would just really like, he has 2 kids that we have been raising together for 5 years, and it's disrupted everything. And I would just really like to either have things work, going through couples therapy and stuff like that, or if it's not going to, and that's what he doesn't want to work things out, then him to be able to come get his stuff from our residence.
Sure.
And take his stuff.
Sure. Where are the kids now?
Well, they're his kids, and they're with him now because it's his time during the summertime, I believe.
Okay.
So they go back and forth, but they are with us every weekend except the 3rd and the 5th.
Okay.
So this has impacted a lot of people.
Okay. All right. Anything, Ms. Camry, that you wish to add?
Your Honor, in addition to that, I would just highlight that Mr. Rankin hasn't had any criminal history for 10 years and had that one incident back then. He will need a civil standby. So if the no contact order is not modified or rescinded, then that is in there and he would need that. And so ask that the no contact order be rescinded in its entirety.
All right, I'll hear from the city.
Trying to follow the case,
I think the city, as far as rescission, would certainly like the court to have the advantage of a domestic violence provider's input. The city wouldn't have any objection on the modification.
This is in Washington.
City is objecting to rescinding it at this time without input from a domestic violence advocate or a domestic violence trained person. Is that correct?
That's correct.
Any objection to allowing text, telephone, and third-party pickup of the dog?
No.
Okay.
Is that a Mountain Dew?
The court is going to modify the no contact order to allow for virtual and telephonic contact, to allow the third party pickup and exchange of the dog, and to allow a one-time civil standby for Mr. Rankin to come by and get his belongings. I will also allow, if the parties choose to go into couples counseling, I'll allow contact for couples counseling in the presence of the counselor only. So you both arrive separately, leave separately, but can attend counseling together with a third person.
I've got to hear Terry's case.
Is the city, does the city have a order?
No, I was going to do it.
Okay.
I don't know
if you want me to.
It's going to take me about 5 minutes. You can take some other cases, but I'll have that done momentarily.
We're not there yet, but yes, I will ask. All right, so the city's going to work on making those changes. We'll get you a copy to the modified no contact order today. If you do want to come back to court and the therapist is recommending additional contact, or if he does domestic violence treatment and that person is recommending rescinding completely the no contact order, you can always come back to court and ask for that at a later time.
Are we able to talk about if we're going our own ways?
Yes, you can discuss.
I just want to clarify.
Yes, you can have any conversation you want as long as it's not in person.
Okay.
So you can have virtual, conversations, video conversations, phone, text, email.
Just not in person. Okay.
Just not in person. The only time you will be in person is with the therapist.
Okay.
And then any third party, but it can be the father, but any agreed upon third party can exchange the dog.
Okay, thank you.
And then he needs to contact Mr. Rankin. You need to contact your local law enforcement, let them know that you have an order authorizing a civil standby. It's not a priority for the police department. When they will schedule that with you, and you'll have a chance. This is not a chance to move furniture or anything like that. This is a chance to go in and get essentials. So medication, toiletries, clothes, grab a bag or two, and that's about the time you're going to have.
Okay. How do I go about getting other things if that's where it goes?
You'll have to do that at a later date. So after if the no contact order is lifted, you can do that after that time. You could also ask for a third party exchange of those things at a later time. In other words, you're exchanging the dog. I would have no objection if the parties have agreed via email or phone that the dad is going to come over and pick up a dresser or a bed or any other piece of furniture. That's fine. It's just not going to happen during the civil standby with the officers. They don't have time for that.
Okay. And that's what I assumed.
Okay.
Okay.
All right. So okay. So now let's talk about court dates. We've got the next court date is readiness on the 8th of October with backup jury trial the 16th and the 17th. Are we keeping those dates? Thank you for coming to court, ma'am. Don't leave without a copy of the order.
I will. Thank you.
Yes, Your Honor.
City is fine with keeping all of those dates.
Yes.
Okay. So your next court date, Mr. Rankin, is going to be the 8th at 9:30. October 8th at 9:30.
Okay.
Terry,
if
hurry
you
and
have any
swallow whatever
questions
you're
about
eating.
the civil standby, the amended no contact order, contact your attorney, okay?
Okay. Thank you.
Don't make any assumptions. Just contact your attorney. They can give you detailed information about what it allows and what it does not allow.
Okay. Awesome. I think I got everything.
Okay.
Terry's looking at the
and
clock.
we
It's
confirmed
like
your
it's break
address
time
and got
over
your
yet?
new address and phone number. So we'll see you back on the 8th.
Awesome. Thank you very much.
Okay.
Bye-bye.
Hold on one second, sir.
Yes.
He almost clicks. He almost clicked that big red
We'll
X.
resend it again because he has a new address. You're asking. I mean, he has actual notice, but does the clerk?
I just need to know,
Well, he has notice because I just told him. So he has actual notice. Sir, did you write your dates down? October 8th at 9:30, and then jury trial on the 16th and 17th at 9.
Yes, I have those written down.
Okay.
Did Terry
and
just take a
the 16th
selfie?
and 17th is in person if it comes to that.
Okay. I'll make note of that.
Okay. All right.
Terry is a no napkin sort of guy.
Okay.
You mean to resend notice it cancels?
Yeah, because
Oh, yeah, I don't want to do that.
We're in Thurston County, Washington.
Oh, okay.
This trial.
Okay.
District Court 2 up there. I'm here for Terry. Hard hat, safety glasses. I think he has a fall protection harness on as well. So he's got the full PPE outfit.
Okay.
Preps for court.
I'm just taking notes
Hey,
on the
Attorney
exceptions
Swenson.
that are going to be listed in the
Hair
no
looks
contact
great, sir.
order,
Looks
and
great.
then when the city has that ready, take your time. But when it is ready, do let me know because I otherwise will not know.
Ooh, an
All
ear
right.
exam for Terry.
Mr.
Looks
Rankin,
good, Terry.
You're free to go.
Looks good. You're all
Thank
good.
you very much. Have a good
No
afternoon.
problems there.
Thank you. You too. Miss Camry.
I'll do it again. Yeah,
Your Honor,
I'm not
those are
seeing
all the
any
cases
infection
that
or
I have
anything,
ready.
Terry.
May I please have a breakout room with Gabriella Neufeld?
Yes. All right. And who do we have in the courtroom that's still here for court?
Shane Iverson.
Shane Iverson. All right. Mr. Iverson, have you talked to your attorney yet? Okay. Is it Miss Camry or Mr. Swenson?
It's me, Your Honor. I'll give him a call in just a minute.
Okay, perfect. All right. He's here. And then, sir, what's your name?
Cody.
Last name?
Halberstadt.
Cody Happerstadt. Just walked in the courtroom as well. That's on our 10 o'clock docket, number 3. And is that Mr. Swenson as well?
Yes. Let me just see one thing on that.
Terry straightening the hat, wants to be presentable for court. If the judge asks him to take it off, he's like, I can't.
Competency evaluation
It's a
filed,
safety issue.
July 24th, Your Honor. This is set for trial confirmation, but I think at this time it should be set for
All right,
confirmation.
let's call the case. Mr. Happerstadt, come on up. This is cause number 3A0732809. This is number 3 on our 10 o'clock docket. Good morning, Mr. Haberstadt.
Good morning. Sit. Go.
Okay, so sir,
That's not
are you
Justin Timberlake.
still receiving mail? Let me double check that we have your current address.
Sorry.
That's all right. 330.
Yeah, yada, yada, yada. 123 First Street.
We eventually changing address for
Okay,
mail.
but right now that's your current address.
Correct.
Okay, all right. And so Mr. Swenson is indicated to the court that a competency evaluation, what did you say, an evaluation was filed or a motion was filed? An order.
The order was signed and filed.
7/24/24. Okay. So we have an order for competency. Obviously, that's going to take time. We're not going to do anything today. What are you proposing, Mr. Swenson?
Resetting this probably 3 months, 2 or 3 months, Your Honor. I know those out of custody evaluations.
And then I do have I've been doing very well, and I've been not smoking weed for a while.
Okay, you don't need to.
I want to say this so that my lawyer knows that I've been stopped smoking weed. She's been helping me with my stress, anxiety. I got apartment lined up and a job lined up.
Great. Awesome. Okay.
My life's turned around since I got my service dog.
Oh, good.
That's awesome.
What's your dog's name?
Polar.
Polar. All right. So we're looking for a December date.
Dog is opposed to smoking weed.
Yes.
Dog eats all the weed, so I
September
can't smoke it. I think that's what he was trying to
September
say.
11th and September, January.
That's good. He's made some changes.
I mean, the
Service
holidays are
dog.
terrible anyway, so
They
we should
are
do
amazing.
it
Oh
mid
my
to late
goodness.
January. Yeah.
Love the dogs.
We're going to set it after the holidays so we can have time to get your assessment.
All right, that's perfect.
Okay.
Terry used to give Polar some Doritos.
That's fine. January 28th at 10 o'clock. Does that work for all the parties?
It sounds like he's taking the steps that are necessary to.
All right.
So that's a good thing. It usually works out well for them.
And I do have a quick question. When I do change my address, do I need to come here and let you guys know?
Sorry. Yes, if you change your address, you don't need to come here. You can call.
Okay.
You can send an email. You can go online, but you do need to let us
Carrier
know and your
pigeon.
attorney know anytime you change your address.
All right, no problem.
Okay. All right. So are you printing him?
It's time for me to place my order.
Contact order is in your.
Jasper,
9 o'clock folder.
I'll take
Let me
I'll take
see.
a Big Mac, large fry. Actually, make it 2 Big Macs, 1 large fry. Do you have Mountain Dew? No. Oh, is this not the drive-through? I'm so confused.
All right.
Hey, you reckon I'm still waiting on my call me for court? They haven't called me for court yet. I'm still waiting on Zoom.
Terry forgot to be muted. Terry has finished off the whole bag of chips. And no Mountain Dew. Jasper's like, I'll see you, Red Hat, and I'll raise you a bill. Gabrielle's back. Attorney Swenson's back. I'm gonna have to be off camera here. Oh, let me see. I'll go up top. I'm gonna wander right up here by the judge. Oh. Now, of course,
That's your next court dates for next year, 128. All right, 925.
I'm going to be up here where the judge is because we already see her twice.
I don't know what you're talking about. Hold on one second. Telephone, virtual, 9 o'clock.
I just don't want to miss. Oh, Terry's got another bag of chips. We are good to go for another round, Your Honor. Take your time.
So I'm going to add on
These
this
are the
order
spicy nacho
the
ones.
civil standby.
It's
Is it in
almost above your signature.
Oh, it's on the bottom.
Jasper is either grading papers.
Yep. Okay. See, yep, I got it. Number 8. Great.
He's talking to somebody. He might be practicing the rap. I think he's spitting down some bars. He's practicing his rap like we saw before. Last week we had a defendant who was practicing a rap, waiting for court. That or he's acting as an auctioneer, the way he's turning back and forth, scanning the crowd, looking for those bidder numbers. Terry has now gone upside down. He feels on top of the world. Terry's trying every angle to see which one is his best. That was not it. Nope, that one's not it either. He's now raiding the offices to see if other people have bags of Doritos. Jasper's smug in the knowledge he has several bags stashed away.
Ryan Rankin matter. So she'll print that out for you in just a moment. All right, Mr. Swenson, do you have other matters that are ready?
Your Honor, I do, but could I get a brief breakout room with Terry Ayers? I know he's anxious to get out of here.
All right, you want your breakout room. Do you have other matters you want to do first, or do you want to be put in a breakout room now?
A breakout room with him first. It should just take a minute.
All right.
Problem is Terry.
Miss Camry.
Terry just went away.
Your Honor, we proceed with Gabriella Newfield.
Will do.
Man, people are popping up all over the place. Who's this Brian guy? Oh, he's doing the same Terry move, trying to find the best angle.
All right.
Terry's anxious. No, those are just the munchies, lawyer. Those are just the munchies.
I'm just going to confirm your address with you, Miss Newfield. Are you still receiving mail at the 7747 21st?
Sorry.
Yes, ma'am.
And are you still getting text message reminders for court?
Yes, ma'am.
Okay. This is number 8 on our 930 new bill.
I think Jasper works as
All
a
right, go
day
ahead,
trader.
Miss Camry.
Your Honor, I filed a motion to continue with the speedy trial waiver. We're asking that dates be stricken.
All right, any objection from the city?
None.
So what we're going to do, Ms. Newfield, is we are going to strike your hearings for September 11th and September 12th. And did your speedy trial waiver commence today?
Yes, Your Honor.
So with a new speedy trial, let's see if we have that.
This is the weirdest thing. So they run out of time on speedy trial, so they file another new speedy trial. How many speedy trial waivers do you get?
I don't see it in our file. Do you see the motion to continue? Okay. We're looking for just for the motion to continue, but on your oral representation that there's a new speedy trial waiver starting today, the court will grant that motion. Do you want to set this out for pretrial?
Yes, Your Honor.
And you're looking for a September pretrial date or October?
October, Your Honor.
Did you ask her how she sent that?
Yes. How did you send the motion to continue? We don't have it.
I sent it to the clerk, Your Honor.
Oh, that's why.
Okay. This morning?
Yes, I did get it.
Okay.
Yeah, I've got it too, so.
Okay, so speedy trial through December 2nd. And a new pretrial date, we're looking for October. Mm-hmm. Mid-October is fine.
October is actually pretty full, 48.
Whatever works.
I do have an opening for
October 22nd?
10:30.
At 10:30 a.m. All right, so we'll see you back here, Ms. Newfield, October 22nd at 10:30 a.m. for a pretrial. Stay in touch with your attorney between now and then, all right?
Yes, ma'am. Thank you.
Okay, thank you. You're all set. Have a good day.
Thank you too.
Thank you. Ms. Camry or Mr.
Your Honor, may I have a breakout room with Brian Sanchez?
Mr. Swenson.
Yes, Your Honor. We can call Terry Ayers.
All right, Mr. Ayers.
On the 9:30.
Terry.
Number one on the 9:30.
Attorney said, yeah, lose the hard hat and then stop with the chips.
895 on for confirmation of trial. Good morning, Mr. Ayers.
Good morning.
And Your Honor,
Are you still receiving mail at 261?
123 ABC Street.
Yes, ma'am.
And you're getting text message reminders for court?
Yes, ma'am.
Stop
okay,
drinking.
and we have trial set for September 11th and 12th. Go ahead, Mr. Swenson.
Thank you, Your Honor. Defense is confirming for trial on September 11th.
In the city?
Likewise.
All right.
Jasper says September 11th?
Your trial will proceed as set on September 11th. You need to appear in person, and you have obviously good
Jasper's
contact with your attorney,
chair.
and they can give you any other details that you need to know, but you need to be in court in person 9 a.m. on September 11th.
Yes, ma'am. I'll be there.
I misread
right,
this whole
thank you.
situation.
That takes
Jasper's
care
a
of
pro
this matter.
Fortnite player.
Thank you. See you guys next week.
All right. Thank you.
Thank you.
Your Honor, Caden Burris is present on Zoom on the 9 o'clock calendar.
No, Terry can't hang up. He can't figure it out. There's
Hayden
Caden.
Beers, cause number 4A0570999, number one on the 9 o'clock.
It's
Here for
Bearsay.
a first pretrial. Good morning, Mr. Beers.
Good morning, Your Honor.
And Your Honor, Mr. Burris intends to enter a deferred sentence today. I did file a plea of guilty with Madam Clerk earlier this morning.
All right, give us just a second to get that. And while we're pulling that up, Mr.
Who's doing the hoodie?
Beers, are you still at receiving 4-1?
123 ABC Street.
Yes, Your Honor.
And getting text message reminders for court?
Yes, Your Honor.
Ooh.
All right.
Mr. Ritter hitting the vape. Blowing some smoke. Yeah. Off camera. Quick exhale. Nobody saw you. It's okay. We caught Caden during the middle of his photo shoot for his rap album. I'll continue here in just a minute.
All right, Mr. Beers, I'm going to be going over with you a plea. Thank you. And this is to, you're charged with 1 count of theft in the 3rd degree, carries a maximum penalty of 364 days in jail and a $5,000 fine. You are Caden Phillip Beers, you're 19 years old and you've gone through the 11th grade. Is that all correct?
Yes, Your Honor.
All right. By pleading guilty, you understand that you're giving up the following rights. You're giving up the right to a speedy and public trial, the right to remain silent, the right to hear and question witnesses, the right to testify, the presumption of innocence, and the right to appeal. So what that means, sir, is you're not having a trial. You understand that?
Yes, Your Honor, I do.
All right. And there's a recommendation being made to the court. The court does not have to follow anyone's recommendation and can sentence you anywhere up to the maximum. You understand that as well?
Yes, Your Honor.
All right. And your statement of facts in paragraph 11 is on July 26, 2024 in the city of Lacey, I took property of Target and intentionally left the store without paying for it. Is that an accurate statement of what occurred?
Target is
yes,
brutal.
Your Honor.
All right.
They do not allow any
are you
shoplifting.
pleading guilty today, given the recommendation, looks like for a 12-month deferred sentence, knowing voluntarily and after advice of counsel?
That doesn't make sense to me. What?
So you understand? No, sure. You are intending to plead guilty today. Is that correct?
Yes, Your Honor.
And you've discussed this with your attorney. Is that correct?
Yes, Your Honor.
And you don't have any questions of your attorney or the court at this time. Is that correct?
Jasper is showing his friend.
All right. I'll make the findings that you're pleading knowing voluntarily and intelligently to 1 count of theft in the 3rd degree. I will hear from Mr. Swenson as to sentence.
Jasper's also trying to explain to his guildmaster why he can't make the raid this afternoon.
I ask the court to adopt the recommendation. I think a sentence is appropriate here. It gives Mr. Burse a chance to have this ultimately dismissed and keep his record clean. He has no history. He's just 19 years old, Your Honor, and he's currently unhoused, but trying to change that and find work.
All right, hold on just a second. Yes, in the 9 o'clock, I've gone out.
Bass Pro Shops making an appearance.
Go back in. You put it in the 9 o'clock, right? Judge, 9 o'clock. Beers.
He's showing everybody he knows the court fee.
Okay,
hey, look, guys.
No problem. I'm going to go there. It's
in
okay.
Court.
No problem whatsoever. Sir, I was just looking for your paperwork.
I can resend it.
I've got it now. Thank you. All right. So, Mr. Swenson, I heard from you. Mr. Beers, is there anything that you would like to say before sentence?
No, Your Honor.
All right. I'll hear from the city.
City has to adopt a recommendation.
All right. I've reviewed your criminal history. I do find that a deferred sentence in this case is appropriate. I will give you a 12-month deferral. Is the agreement of the parties that this case will be dismissed upon the compliance of the deferred sentence terms and conditions?
That is correct.
Okay. At the end of the deferral period, at the end of the 12 months, if you meet the conditions shown out on this order, this case will be dismissed. So you will not have the theft on your record. The conditions are no law violations, no criminal law violations, no contact with the target in Lacey. Do you understand that?
Yes, Your Honor.
Okay.
It's tough. Hope we get some.
So as long as you don't get any new charges and you're not at the target, you should get the benefit of this bargain, which is a dismissal.
Thank you, Your Honor.
I'm thinking Blood Elf, Adriella.
All right, I've signed off on the plea form. I'm signing off on the judgment and sentence. You can get copies of these forms from your attorney or off of our website in a couple of days. All right. Good luck, sir.
Thank you, Your Honor.
No, they didn't have any fines in the.
Okay, we need a couple of our regulars to come back. Where's Brian at? Where's Where's our gamer? What was the gamer's name? That wasn't Caden. That was I can't remember. What was the gamer's name?
Just signed this 2023.
Red is
Yeah.
dead, Benny. Red is dead.
Yeah, it was a long weekend. Okay, 9/3/2024. Okay, here's the plea signed. I signed the judgment and sentence. Mr. Beers is good. All right, Mr. Swenson.
Your Honor, I can call Jaden Dietrich on the 8:30 calendar.
All right.
Paging
Jaden
Jaden.
Dietrich, 3A0854189, 4A0501979, and 4A0530318. And where is Mr. Dietrich? Is he on the?
He's appearing through counsel, Your Honor. I'm waiving his presence.
Is this a waiver?
Yeah. And we're just asking to leave date set. We have trial confirmation coming up in 2 weeks, September 17th at 10 a.m.
All right. There's also, okay.
Right.
There's
Firearms that we need to address next year.
I will be filing, or my office will be filing a declaration of non-surrender. There was previously one filed in an older
Declaration
case, Your Honor,
of
but
non-surrender.
Nothing's changed, but I'll get an updated waiver filed. Or
It's like I'm keeping my
declaration.
guns.
firearm proof. Okay, so a firearm waiver will be filed by defense, and we're leaving, you said leave the dates as currently set. So readiness on 9/17, jury trial on 10/2 and 10/3. I'll waive your client's presence, 4.3 waiver, and leave dates set. Anything else on Mr. Dietrich?
Your Honor.
All right, that takes care of that.
And then Cassandra Martinez on the 8:30.
All right, 4A0419865 on for confirmation of trial. Cassandra, are you waiving or is she present?
Waiving.
All right, go ahead.
Your Honor, this is a defense motion to continue. Ms. Martinez did complete an evaluation of Northwest Resources. We're just waiting to receive a copy of that and to negotiate before negotiating with the city.
I'll hear from the city on the motion to continue. I think there is a waiver that was received that goes through December 2nd.
Yeah, no objection.
Zachary,
So that's just
hit the
reset for
1 month.
pretrial.
Thank you, my
Reset
friend.
for pretrial. And you wanted a December date?
No, Your Honor, if we could actually set this for pretrial in October.
Oh, right.
Expect to have that evaluation in the next couple of weeks. So,
October 22nd work?
yes.
All right, October 22nd at 10:30. I'll waive Ms. Martinez's presence, so speedy trial waiver through 12/2/24, and that was a pretrial.
Zachary comes in
On
with
October
5
22nd.
gifted
All right, that
subs.
takes care of
Thank you very
Martinez.
much, Zachary. Your generosity
Thank you,
is
and-
legendary, sir.
That's all I have ready at the moment. I believe.
Mr. Ritter, your client?
Mr. Ritter.
No, Your Honor, that's Canaries.
Okay, and did you get a chance to call Mr. Halberstadt?
Mr. Iverson is present in the courtroom. I need to call him, and I also see Taylor. I think that's Taylor Haggard on the Zoom call.
Haggard? Haggard is here?
Yes, sir.
He needs to come up here so he can hear.
Yeah, come up here so that to this table so he can hear you.
Mr. Swenson, I don't know if you have my new phone number, but that's
867-5309. He's speaking to the picture on the wall. That's actually just a portrait.
Did you get that from Iverson?
Sorry, Shane, 253.
867-5309. Yes, 5309.
51.
5309.
Okay. Thank you.
253.
867-5309. How many times do we have to do this?
Be put on the texting list.
Yes, she's doing that right now. And any changes to your address, Mr. Iverson?
It should still be 30.
Should still be 123 ABC Sesame Street. Man, this one's brutal.
Swenson, you're going to call Mr. Iverson?
Yes, should I?
3315 South.
Oh my goodness.
Yeah, I'll do that first and then I'll do the breakout.
Why don't you just hold your driver's license
Taylor
up to
Hacker.
the camera so we can't mute it?
Okay.
Okay, thank you. Go ahead and step out. He's going to call you. All right.
Man, that was brutal.
And if Ms. Camry has
the efforts
anything
I go
ready.
to keep people anonymous.
Oh, okay.
Where's Jasper at? We're ready for
She's
Jasper.
working on some paperwork.
I'm sorry, Your Honor.
No, that's fine. I didn't know if you had anything ready. I wasn't sure.
You got Jasper.
Jasper
Ritter.
Okay, may I please have another breakout room with Brian Sanchez?
That's not what we wanted. Yeah, fun fact, all those details are public record and anyone can walk down to the courthouse and get them.
The person, Jasper Ritter, I cannot, is he an add-on or something? I see him now. Okay, never mind. He's
There he is.
1030 with James Dorr. Is that private counsel? Yes. Okay, so his attorney's not present.
James
Okay.
Stewart, also his brand manager for his gaming team. He's early, so Mr. Ritter will be back.
Okay. All right, court will be in recess.
Let's see, they go to recess, so we're going to sit there. Let's see who else is currently around. Judge Cedric is doing something secret that no one will ever know. Let's see. Let me take a look outside while we start scouting. Who else is up and about in court today? Some jury selection going on. We had the Donna Adelson motions hearing last week. Or wait, was that yesterday? I think that was yesterday. Who works on a Labor Day? Let's see. Simpson or Boyd, says Laura Fry. Let me check and see if we've got either of them. Simpson's not doing anything interesting. He's been private all day long. So nothing yet. Let's see. Judge Boyd was live a couple hours ago. It's not now. Young Thug is going on. Judge Brantley is selecting another jury right now. He's got a room full of people.
Why did he have it? Why, So I would think you would have to.
Well, he didn't, but we'll get to that next week or tomorrow.
You would have to show us or have some kind of counter to the state's evidence of it.
I appreciate that. And so that's the right answer for Mr. Valverde, because it's the true answer, right? Does anybody agree with that? Anybody feel like if you don't present any evidence and the state has witnesses and evidence, I'm going to impose some kind of burden on you to disprove that, or to prove your innocence, your client's innocence. Anybody else feel like that? Agree with Mr. Valverde? Mr. Dick?
Yeah.
You're shaking your head yes?
Yeah.
Do you think it would impact your deliberative process and make it more likely that you find the defendant guilty of the charged offense if I don't present evidence or try to prove his innocence?
Yes, sir, a little bit.
Okay.
I don't understand how the jury system works.
Mr. Atkinson, is that ambivalent? What are you thinking about lunch?
Well, I was thinking about it a bit.
Yeah.
On one hand, you shouldn't have to, but on the other hand, am I really going to be able to, give him the doubt without any help, right? And not just, I know he's supposed to be innocent until proven guilty, but
we all know.
Am I able to, is that able to stay at the forefront after I've watched someone do a whole accusations, whatever it's called, prosecution. Like after they've done their whole thing, it's innocent until proven guilty. You're gonna be overcoming that, right?
You think it might be difficult for you?
Yeah, it'd be difficult.
Okay. So I guess let me
three people off the jury
on that issue a little bit more with you and seek some clarification there. So really what we're talking about, it sounds like for you, is a situation where you think he probably did it, but you have a reasonable doubt. Right. So this ultimately comes to the question of, can you follow the court's instruction to put the burden on the state, hold the state to its burden, and force them to prove each element beyond a reasonable doubt?
On the opposite side of that, like I know that we should definitely follow innocent until proven guilty. It's just, as a person, I don't know if I'll be able to like hold that against a competent prosecution, right?
I understand. Yes, sir.
I don't.
Anybody else have thoughts on that point? Yes, ma'am.
A prosecutor who had all this information and you represent him at very little. It's not here or there. It's actually, oh, he's more guilty than he is innocent. But it can't be a middle confusion of not knowing, okay, I really don't know. I don't have all the evidence to prove otherwise. But I don't want to say that this person is actually guilty because this person representing him didn't have all the papers, everything on board.
Well, you're making a really good point there.
We're going to jump down to...
It's probably important to distinguish what you just said from some of what the other prospective jurors have said. If the state comes with a mountain of evidence and proves beyond a reasonable doubt he's guilty, okay, but and that's it, right? Then under those circumstances, following the law means you find the defendant guilty. If on the other hand, it's a circumstance where you have a reasonable doubt, as that term is defined by the court, and yet you still say, I don't know if I can find this guy not guilty, that's what I'm talking about. That would be a problem, and that would create a circumstance where you wouldn't be follling the law. If you believe
right, let's
that there was
jump
a reasonable
from jury
doubt,
selection
still willing to
up to a brand new judge. How did the audio get worse? Oh, I think that's just somebody talking. Don Smith, JD. Is he our judge? Got some peeps in. There's our. Let's see. Iona.
You want to start with
8th Circuit Court.
We start with State versus Jason New. File number 18S17557FC. This is the time set for defense motion for trial. Appearing for the people is prosecuting attorney Caitlin McBride.
Can I just ask quick, because this is a motion, it might take a few minutes. Don't we have some inmates? Two DOC vans here today. That was your clients here?
Yes, I have two that are here in person.
Why don't we call them first? We'll get back to that. Thank you.
Okay, we're
Yeah,
switching.
Waters and Charles Johnson.
All right.
Waters.
You said Washington and Waters?
Washington and Waters. Just Judge Schaefer.
Yeah, Waters.
I cannot find a court with good audio for them.
We have the other SLF online.
This is following different whereas 19096FC State of Michigan versus Monte Waters, daytime set first report sentencing. President courtroom.
All right, Mr. Downs, you had an adequate opportunity to review the pre-sentence report and the sentencing information.
Okay, this one's no good, so we're jumping.
There's no additions or corrections to.
Let's see. I think we're in, Judge Jason Elmore's court. Misaki 28th Circuit. Where's Misaki?
Is Mr. Winworth living at two addresses? Got at each one. I was covered the same date, May 29th, 2024. The Wexford County case, its exhibit, the Michigan State Police report has an address of Mitchell. And then the Missaukee County Sheriff Incident Report for the same date has a residence here in Lake City.
This is Michigan.
So can somebody explain that to me so I can cover the...
What's the address in Lake City?
It is
123 ABC Street.
Oh, that brother's address. That was the address on my ID.
Okay. Let's take a look here. I'm going to investigate further. Okay,
Silly Pick. Thank you. Welcome. Congratulations for 3 months.
Okay, that in the Missaukee County case, that apparently occurred during a traffic stop, and that traffic stop occurred in Lake Township, and that is reported on page 4 of 38 in People's Exhibit number 1, file 3513. One moment.
Judge Elmore is reading the details of the traffic
stop. And what page were you guiding me to?
I believe page 7 was the page that referenced where the narcotics were located.
Thank you. I see.
That was loud.
All right. In that particular file, I'm going to move chronologically and go back to Mr. Denhout on behalf of Missaukee County, file 3513. Now, Mr. Denhout, do you believe People's Exhibit number 1 provides a factual basis for the acceptance of the no contest plea as to count 1?
I do indeed, Your Honor.
Mr. Champion, do you agree?
I agree, Your Honor.
Mr. Denhout, are you aware of any other promises, threats, or inducements?
No, Your Honor.
Mr. Champion,
I'm aware of none, Your Honor.
Mr. Denhout, do you believe the court's compliance with Mission Rule 6.302?
I do.
Thank you. I will note that on that page, and actually in several different spots in this report, there is a factual basis, particularly that the defendant was in a backseat vehicle and directly where the defendant was located, there was this controlled substance, and that substance tested and proved to be methamphetamine. The court further finds, again, that based upon the stipulations we've already talked about extensively on the record, that the interests of justice do not require the resuscitation of a factual basis by the defendant. Again, the court finds the plea to be made freely, knowingly, and voluntarily. The court further finds that, the information contained in this report, incident number 24-1154-157, satisfies the factual basis. Therefore, in file 3513, in the Missaukee County case, the defendant is found guilty of count 1, and the enhancements will be dismissed. The court further finds in file 22-33. Hold on. Yes, we already covered the plea. In file 22-3349, the defendant is, based upon the other finding, found guilty of count 15 of the probation violation. Mr. Let's take a look here at your file. Okay.
Got something out of Thurston County right now as well. A little different thing. It's a protection order here.
The court turns its attention to, for the record, page 2 of 6, as well as some of the attachments in the back, such as, well, I said 2 of 6. There's actually attached to that additional pages. There are 3 TrueNarc tests that are associated with that report. This event occurred on or about the same date. Looks like there was a search warrant authorized by the defendant's probation agent, Ms. Laura Odell. And that search was conducted at the place in which the defendant was residing, which the court is familiar with, the Econo Lodge Motel in the city of Cadillac. And then it is often a location for transient individuals to reside, and many of whom tend to be on probation. Mr. Wiggins, do you believe that this report provides a factual basis for the acceptance of the plea in your case?
I do, Your Honor.
Mr. Champion, do you agree?
I do, Your Honor.
Mr. Wiggins, are you aware of any other promises, threats, inducements?
I'm not.
Mr. Champion?
I'm aware of none, Your Honor.
And Mr. Wiggins will be the court's compliance to Mission Court 6.302.
I believe it is.
Mr. Champion?
Yes, Your Honor.
Thank you. The court finds that, again, that based upon the same information earlier discussed on the record, that the interest of justice do not require the defendant to recite a factual basis based upon his.
We're going to jump from this one.
Very frequent use of.
All
right. To Thurston.
So, the thing was that I paid for it every time.
Ketsy, welcome.
And I paid
So
for
you need to be quiet, ma'am.
I paid for that to happen every time.
So, Mr. Fields, we're almost done. We'll start with you in a minute. That's fine. So, here's what's going to happen today. So basically, yes, ma'am.
May I make a motion to dismiss?
We'll just stand by for a minute. Let me
Okay.
tell you what I'm going to do, and
Thank you.
maybe that'll take care of it.
Okay, thank you.
And so, with regard to, again, there's 4 separate actions here. Ms. Struble is asking for an order against the Hares, and then the Hares are asking for an order against Ms. Bigelow, and then both Strubles. But so essentially what happened here, there seems to be a lot of agreement on what exactly happened here, is that some bushes or trees or some sort of foliage is growing on Ms. Linda Struble's property that occasionally grows, as things do around here, and it overhangs a fence. In the past, there had been a few instances where Ms. Struble would take care of that, have that paid for, or have that taken care of by a maintenance person who apparently no longer works at this particular establishment, this housing, the senior housing development, I guess would be the best way to put it. And so then that stopped. And then, and when you live on a piece of property and some tree or a bush on the adjoining piece of property overhangs onto your property, it's your responsibility and right to take care of that. And it's not appropriate to, which should be intuitive, I would think, is just to cut it off and then toss it into the neighbor's yard. And again, there's some dispute as to whether or not they'd been told whether you can or can't do that. And then Ms. Bigelow, is my understanding, was that in the bylaws?
Yes.
Okay.
Well, not tree branches, but you can't harass a person continuously.
And so I find the act of, cutting the branches, frankly, that's going to be your responsibility. Ms. Struble was doing you a favor over the years for having that taken care of, but if it overhangs onto your property, you can make arrangements to have that cut. You might have to bear the cost of that. There are limits on that. You can't do something that kills the tree or anything like that, although which I've seen happen in this arena.
The value of the tree.
And so you can't do that, but you can certainly cut branches that overhang onto your property. What you cannot do is take those branches or cuttings and throw them into the your next door neighbor's yard, which apparently happened on more than one occasion, which I would find that it's a series of acts. Again, you're just doing that just to do it, and for lack of a better term, get Ms. Struble's goat, which you clearly did. So I will find that activity is harassing. I'll grant the order from Linda Struble requesting the order is you're just not to talk to each other. There's no distance restriction or anything like that. So it's not going to affect your ability to go to and from your house or anything like that. You just can't have, for the next year, you're not to have any contact with Ms. Linda Struble. Do you understand that?
Yes.
With regard to your petition against the other 3, those are all going to be denied. I don't find there was an incident. There was apparently a blow up where voices were raised on all parties, but that's not a series of acts over a period of time, which leads to the rebel harassment. So I'm going to deny those orders. But
I think everybody knows how everybody feels. If a pattern does develop, you can bring this back and we can look at it again. But those are going to be the orders here for today. I'm going to grant Ms. Linda Strubel's order, and then your request for orders against all those three will be denied. Go ahead, sir.
Could I have my rights to bear arms and buy a weapon back?
That in the
it was in the order that I couldn't buy, purchase, or have any weapons on my property.
Give me just a second.
Neighbors are like,
I never had a law, anything against a gun, never used a gun.
This might be construed as a threat. He just lost in court. There's a restraining order against him. He's not allowed to say anything to the neighbor for a year. The restraining orders he asked for against his neighbors were all denied. And now he's like, can I buy a gun?
Yeah, no. Again, just by way of background, and domestic violence related orders, yes, that does for a surrender of firearms. In these sorts of cases, anti-harassment, in order to find some sort of, like if a weapon was used. And so it's written in there, but that was never part of the order. The box needs to be checked for you to surrender weapons and all of that. That box was not checked. So your firearm rights were never affected one way or the other.
Fine. That's great.
And so the order will see. So do you have a full order and deny? Good, thank you. So give me just a stick.
Attorney's like, shush, shush, shush. Don't say anything. Don't say anything. Don't
give me a few moments to fill these out, and then you'll all get copies of them, and you'll all be all free to go.
It's awfully quiet in court right now. Well, all this over some trees. I can't say that I can't relate, because in a way I can. The law.
The parameters of the order: you're not to cause her any harm. You're not to contact her in any way. You're not to engage in stalking behavior, like following her around or anything like that. In terms of exclude and stay away, I didn't check that box. I have distance restrictions. Don't come within the 1,000 feet or what have you. That's not in place, but you're not to come onto her property and you're not to contact her in any way. Do you understand all that?
Yes.
And then this order will exist for 1 year. And if you feel it necessary to renew that before the end of 1 year, you can do that. Hopefully, this will work itself out where that won't be necessary. Ma'am, younger Struble, I did hear you mention that you're willing to arrange to have those things cut. There's nothing to stop you from doing that on your own. And then I'm just throwing that out there.
Thank you.
But it's not required.
We're going to look at it and see if there's something we can do here. Avoid this.
All right. Judge is signing all the paperwork. We should be done here. Lady in gray still wants to speak. The attorney's told her not to.
They and her get a copy of that one. And
She's thinking it over. I had to study tree law. My backyard neighbor at the infamous tree house, not where I live now. We had a tree that was planted on our side, but grew to touch the property line. And the neighbor didn't like it because the branches did overhang their house. And I told them, according to the law, that they're welcome to cut back any offending branches they need to. But if it killed the tree, legally I had the right to sue them to 4 times the value of the tree. At a full-grown tree like that, it gets quite expensive.
Sorry.
And
everything is not.
when we sold the house,
Technology is not their friend.
they cut down the tree.
Mm-hmm.
I liked the tree. It was the only shade we had in the yard the kid played in. We cut down 3 other trees along the fence line, so there wouldn't be a problem. But that one, is she typing in chat? Is the attorney typing in chat right now? Sewing Mama, welcome to live. Thanks for watching the replays. How's your cactus? I was not able to visit my cactus in the time that I was here in Utah. I don't think I'll be able to. I hope it's still alive. I did go to the to Red Butte Gardens, which is a botanical garden. Beautiful, beautiful garden. Had tons of cactus that were blooming, and I took pictures for Adam Nusky. Beautiful. I've got a video, Adam. I need to send you a video. It's just for you. Let's see. Cactus Mortis. Not sure what's taking so long here. It's just a simple order. Yeah, tree law is a thing. Most states are pretty much identical to what this judge cited. You're welcome to cut down stuff that overhangs in your yard as long as it doesn't damage the health of the tree. And it takes an expert sort of to look at that. But it's always better if you can just talk it over nicely with your neighbors. I'm waiving my cactus visitation rights. I just don't know where it is. I think he took it to work. Which I had the cactus at my work for a while as well. Had a family member move into a newly built neighborhood. It was a slice of nature preserve. They've been opened up. No big trees could be cut down. They had to be planned around. Yeah. Sarah Boone's lawyer is not pro bono. He held a press conference after court and said he was hired and being paid by Sarah. The judge says he was pro bono, so apparently that he was retained. How much he was retained for, I don't know. All right, new merch. I went all the way to Utah and took a picture of a cactus. Let me see if I can pull up this cactus picture. Let's see what plugs would I need to use to let you see that. This one. This is the plug. Now I just need an open HDMI input. Eight, 7, 6, 5. What is 5? Five would work.
Mr. and Ms. Hare, you can get copies of these orders too if you want. There's more. We have to do orders of denial also. You can get copies of those. I'm going to step off for Mr. When you get those, you'll get copies of all those too. And then Mr. Fields, when the table clears, you can come up and take a seat there at that table.
All right. First, do not disturb so nobody's numbers come up. Okay, while he's stepping off, let me see if I can show you a picture of the cactus. Let's see, a little video.
Want copies of the denials?
Please. We didn't get to thank him. Will you thank him for us?
What was that?
We didn't get to thank him. Will you thank him for us? Thank you.
All right, here we go. So this is a picture. You know, that's family and friends checking out the botanical gardens yesterday. I think this is the video for Adam. Let me play this. Adam, this is for you, just for you. Why do I have no audio? Check out that barrel kick. Hey Adam, I caught you these delicious succulents. So there you go. Say I would never give anything to you. Check out that barrel cactus right there. Looking good, looking good. There you go, Adam. There's your video, just for you. I mean, who else would go like 2,200 miles and has given one thing to me? Went 2,200 miles. I do want to show you one more thing. There was a. Okay, so we have. So, Mrs. Ari and the kids looking at the map to see, there's a waterfall right there. But underneath the waterfall, I took the picture and then I looked up and I saw this right above my head. Yes, these little guys just crawling around. That was like a foot from my hands and my face when I did that. But anyway, botanical garden was beautiful. I want to show you one plant. Okay, here we go. This plant right here, I need somebody to identify the plant for me. This plant was transformative in my growing up years because I learned that this plant, I heard about this plant and it has a unique feature. This plant, native to Utah, I believe, it is only pollinated at night, meaning it's pollinated by moths that are only active at night. These blooms during the day, they die during the day. At night, when the sun goes down, the flowers pop open. And just like, it's like a pop. It just pops right open. Mom says it's a yellow flower. I have not Google image searched it because I could never figure it out with flowers. I always get like some app that wants to charge me $20. It literally, it just like as fast as popcorn pops, it just like, boop, it pops open. And I've watched this happen. And then during the day, they die. So is it common evening primrose? Was that it? Common makes it sound like it's really common, but I only found one of these plants in the whole botanical garden where we searched. All right, let's jump back to court up there in Thurston, Washington. Waiting for things to get going here.
Miss Harris still back there.
Common evening primrose.
Did she get the denial order too?
No.
Okay.
I didn't see them. I hope they left. So
Okay.
that'll be a little bit.
So Mr. Schwenning, I see you're on the Zoom call. Could you activate your camera? As Mr. Johnson and then Terrence. I think you and Mr. Klingberg were together. Is that correct?
Can't hear you yet. Yes, sir. That's correct.
And you're Mr. Klingberg, and then Terrence is in kind of the maroon shirt whose shoulder I can see. Is that all? There you are. All right. And so, can I get started on this? Or do you need...
What was that?
So can I get started?
You can get started. It's going to be a while before I can get everything's on mixed up.
Okay.
So
So
get started.
hang on just a minute. But
I'm going to need a little bit of time. The papers are all mixed up.
Okay.
It doesn't work.
Okay, so we're going to go ahead and get started. I may have to take a break if, because the clerk is involved in wrapping up the previous hearing. So, Mr. Fields, my mistake, is here in court. He's asking for orders against all three of you folks, and four, excuse me. And so, Mr. Fields, I'll hear from you first. Looks like all your petitions, I did review the petitions. They look kind of similar. And I'm frankly, I'm having a difficult time figuring out where we're at here. So I'm hoping you can clear that up for me. Okay. So could you raise your right hand, please? You swear and affirm the information you provide will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
How is it you need orders against? Again, I'm going to go through each one of these.
Okay.
Start this because this is the order of the calendar.
Mm-hmm.
Mr. Allen first, then Mr. Johnson, then Mr. Schwenning, and then Mr. Klingberg. But before I start, I just have one question. Do you live at Drexel House too?
Yes,
so
sir.
all five of you folks live at Drexel House. Is that correct?
Yes.
Yes, you're right.
Except for Stephen, even though he lives with Terrence, he doesn't live there.
Okay.
He's out of his caregiver, but he's there all the time.
So again, how is it that, why do you need orders against these folks?
Okay, for
Terrence, start with Terrence Allen first, just because he's first on the calendar.
Terrence Allen, he has verbally attacked me. He has followed me outside the building, across the street. Then him and Stephen, Terrence was in front, yelling at me. He spit on me. Stephen was behind him with a knife, and they actually tried to assault me. Then one of the guys came out and pulled me away from there. Stephen tried to hit me with his car. Since I moved in July of last year, I've had issues with Terrence and with Stephen for the same issues. They will follow me to the gas station. Stephen will follow me to the Albertsons. He always has the knife and other weapons with him.
This is Stephen Klingberg you're talking about?
Yes, he does. He will actually
Krista, congratulations.
follow me inside
Thank
of
you so
Albertsons. At home, Mr. Terrence Allen has threatened me over and over. He spit in my face. I called the landlord, and I do have a copy of the December, when it started again, I have a copy of the police report. And the police told me I have the number is 20.
I don't want to know his number.
Okay. And in terms of a police report, I can't get those.
Okay. Well, I did file the police report. They said I had to come here and deal with the harassment first, and then also I put in for small claims as well for the money that they owe me. Mr. Allen has owed me since the beginning of the year. He was going to pay it, and then they got belligerent and said he's not going to do anything, caused me everything.
How much money does he owe you?
He owes me $1,000.
Why?
I lent him money when we went to a casino. Same thing with Mr. Stephen. He has gotten money out of my room and says he's going to pay me back, and he didn't want Alan to know anything about it. He owes me also $1,000. So, and they continue to harass me, saying they're not going to pay me. They drop me off on the corner or try to tag me on the side of the corner. And that's when it all got worse. And that's when I went to the landlord.
And so what do the folks at Drexel House have to say about all this?
They claim that they won't tell me what they've done to them, but it's still happening. Even
they're
yesterday,
still living there?
Yes, sir. Even yesterday when I was leaving the building, Terrence was right behind me. Right behind me. He should not be around me at all. And they continue to do it, even after you gave them this.
What about, I haven't heard anything about Mr. Schwenning or Mr. Johnson.
So we do one thing at a time. I can go to the next one.
Go ahead.
Okay, Mr. Swing, Joshua, he is the one who actually put my computer inside my room. When he did that, he intentionally yelled at me again, I guess he's on some kind of medication. And when he's not on the medication, he will come into the room. He hit me once, then turned around, send me another text message to come upstairs because he owed me money as well. I went upstairs. He opened the door. Then he slammed the door in front of me. I never went inside his room whatsoever. And that's what I reported to the management again, going to their lawyer as well. He says that he has sexually harassed me. And he actually sent a picture of himself in not clothed. And I have a copy of that picture as well. He will continue. His car is in front. He came to
was
where
that
I used to have a
Johnson
vehicle.
or Mr. Schwang that
He
said
came
that?
to my car and said that I owed him money because I should have paid him more money for doing the computer. I paid him the $200 that he asked for. He turns around and took more money from me. He owes me a total of $455 because all the stuff that he asked me to buy, he's now will not do it. And he continues tells me that that I'm a fag, he's a fag, that all of them together, I guess they know each other, Terrence, Allen, and Joshua. And I can't deal with him because when he is not on his medication or when he's doing drugs, he approaches me. And that's the issue I have. As for Mr. Johnson, Michael, he actually in front of Gina yelled at me again. What happened with him was he actually had my vehicle, had an accident, would not, first he said that it was the guy's fault, but he hit the guy from behind. He will not pay me the money that he owes me for that.
So he was in your car?
He was in my car and had an accident. And they totaled the car completely. He did give me $200. I can say that. But other than that, he has not paid the rest of it, which is a total of $5,000. And that's a copy of what the insurance company that I lost.
Okay.
And that's why all of them is together.
Well, let me hear from them. And Mr. Allen, I'm just going to, again, just because this is the order that's on the calendar, I'll go Mr. Allen, Mr. Johnson, Mr. Schwenning, and then Mr. Klingberg. So Mr. Allen, can you raise your right hand?
Terrence.
Were you saying something? Text messages from all of them of what they owe me.
Okay, I don't see, did you file any of that?
No, I tried to get it to it, but I have it here.
Okay. Okay, hang on, just put your hand down there just for a second.
Yeah, I have text messages from them.
Okay. So Mr. Allen, go ahead, raise your hand. Sorry about that.
Mr. Allen, up, down, up,
You
down.
swear to affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. I'll hear your response to what Mr. Fields is asking for. You can put your hand down.
It's just the lag in the computer.
Okay.
Okay.
Let's get the other side of this story.
Oh, okay. So, Your Honor, none of that is true. The part I owe him money is true because we went to the casino and he did give me money to play, and I said I would pay him back, and I just hadn't paid him back yet, which I will pay him back. But the rest of the stuff is not true. There's no. I've never assaulted him. I never verbally assaulted him. I never did any of those things to him. I didn't follow him outside, across the street, or anything like that. I have witnesses here for that incident that happened that night. I have witnesses here that the person that he was involved in, I have them here in my place as a witness, if that's the incident that he's talking about. And I also have the gentleman that he says told him to stop, which is my neighbor, which is the person that lives right next door to me, that they were all there. So none of that is true. The only thing is true is that he gave me some money to play at the casino. I wasn't feeling well. I was going to come back home, and I didn't want to ruin his night and my friend's night because that was driving him. So I decided to just stay in the car. They made me get out of the car and go in the casino, and my foot was swollen so big. It was just huge. And I just was so uncomfortable. And that's it. I owe him money. He loaned me money or to play at the casino, and I pay him back. That's it. I never was belligerent about it. I said I never sent him nasty emails about it or anything like that.
How much do you owe him?
He gave me $200. I also have the text messages from that particular the evening or what have you, and me telling him that I'll pay him back what I owe him. And it's nowhere near $1,000. I don't even know where that came from.
So when did this trip to the casino take place?
It was in March, between March and April. I can look on my phone's charging up.
So about 5 or 6 months ago?
Yes, sir.
Why haven't you paid him back?
Okay. So you guys were friends at one point.
Oh, yes, sir. I had no problems with Mr. Fields. The only time I had a problem with Mr. Fields is, and I'm not going to bring, because that's his old, I told him before that I didn't want him to talk to me or my friends or my guests because he was being inappropriate with them. And they came to me. And so if my guests in my home are uncomfortable, then I'm uncomfortable and I have to address that issue. So I addressed that issue. And I said, told Mr. Fields to cease all conversation with me, all communication with me and my guests. And I went downstairs. I told the resident assistant, I had them log it into the computer, what was going on, and that no longer wanted to affiliate ourselves with him. And that was before even the casino time. And so I didn't speak to Mr. Fields for about maybe almost a year until this past January or December, when I came back from Texas. He knocked on my door and said that there was some food over there at the other building that the Knights of the Columbus had brought over for the veterans. And I was getting dressed anyway. And I said, well, thank you. That was awful nice of you. I said, I appreciate that. That was my first interaction with him after the almost a year of not speaking with him. And so then that boiled down. He started coming back down to the house. And I said, okay, I'm gonna let that water be under the bridge. Well, we had a discussion about the inappropriateness. That still continued on even then. And so I stayed pretty much my distance, and I wouldn't engage myself, but he came down to my home. I mended his pants probably sometime in March or April. What else did I do? I did everything. I even wished him happy. I cooked him food. I wished him a happy Father's Day. That's the last time that I said to any messages to Mr. Field was that a happy Father's Day. And against the allegation of Mr. Field saying that I was behind him yesterday, that's not true, Your Honor. I went upstairs to the 4th floor to get my friend Saka, who is going to help me with some issues I have, some stuff I had to do. And so he wasn't home. He stayed on the 4th floor. So I pushed the elevator, and I got in the elevator from the 4th floor, and I went back down to my floor, which is the 2nd floor. And when I got down to the 2nd floor, when the elevator opened up, there was Mr. Fields there. Why he was on the 2nd floor, I don't know. And so I just politely just walked on by, didn't say anything to him, and went into my room, and that was it. I never followed him into Albertsons. I never said any of those things to him at all. And I read the petition, and and it said that I called him names like the N-word, and then had rape in parentheses. And I've never did anything like that or said anything like that. I don't even talk like that. True that.
Let me hear, and since you're there with you, let me hear from Mr. Klingberg next. I know it was a little bit out of order. Mr. Klingberg, could you raise your right hand?
This would be good.
You swear and affirm the information you provide will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
And do you guys live together?
No, I'm his. Can I put my hand down?
Yes, of course. Sorry.
I'm his caregiver, and he pretty much needs around the clock care, so yeah, I pretty much stay here, but I'm not actually living here.
Got it. Go ahead. I'll hear from you on this issue, on these issues.
Well, as far as the money thing, I didn't know that I owed him anything. He offered to pay me $100 to take him, to let him ride with us to the Emerald Queen Casino, because he didn't have a ride or whatever. So he offered to pay me $100. We go out to the casino and we're on our way back. And now he wants to argue and cuss at us about it and debate what he said he would pay me, you know? And I don't like to argue. I'm not a drama guy, you know? And so I was just like, dude, you said $100. $100 is what it should be. He didn't even give me the $100 in the end. It was, I don't know what it was. I can't remember, but it wasn't no $100. And I was okay with that, you know? And running the car down and running him down in my car, that's just absurd. I mean, he's walking, you know, like I would never try to harm a senior, let alone a veteran. You know, yeah. I have no quarrel with the dude. I don't speak to him on any level. We're all gonna run past each other in the hallways or going outside. You know, we live in the same building. You know, we're bound to run into each other, right? You know, and I don't ever talk to him. I don't ever look at him. I don't even acknowledge that he is there because we've had problems. And he has targeted me before, which is another police problem that happened just recently. It was like maybe a month ago, something like that.
Tell me about that.
Well,
I was
helping, we had a neighbor two doors down on the same floor as us. His name was Dennis. And he was leaving, you know, he got evicted from here. So I was just helping him move because there wasn't anybody else that would help him. He only had a few little things left, you know, enough to fill a car or two. And I was literally in his room, picking things up with both hands, you know, lifting like you would. And I take it all the way down the stairs, and I was stuffing my car, stuffing his car, you know, not even noticing anything else going on. I was completely focused on, you know, getting this stuff done because it was hot as hell that day. Excuse my language. And, you know, we put the last things in the car. Dennis gets in his car and he's already pulling out of his parking spot as I'm getting into my car. But I see Dennis stopped talking to somebody, and it is Mr. Fields. And, you know, so I'm just like, okay, so I get in my car and started waiting for him to get done talking so we can go. I was going to follow him to a storage unit. And at some point I noticed Dennis start to, like, I guess you could say he was trying to holler at me, you know, but my windows were up. So he signaled for me, right? And I'm like, okay, what's going on? And he says, he's trying to find his phone and it's somewhere in this area. And Mr. Fields instantly comes directly toward me, toward my car. Oh, it automatically has to be in my car, you know? And so Dennis, being the good guy he is, and me too, he's like, well, if you want us to sit here and wait, you know, till you find your phone, you know, just to prove that it wasn't us or in our cars, then we can do that. So we did that. And yeah, we pretty much sat there. He called the cops and insisted that it was in my car or Dennis's car, mainly mine. And when the cop showed up, she was like, you know, she pretty much, I wouldn't say she laughed it off, but she knew it wasn't in our cars. She knew we had nothing to do with this.
Is that all?
Let me hear from Mr. Schwenning. Mr. Schwenning, can you,
Terrence, you
activate your camera for a minute?
Oh, is this the gentleman who?
Could you raise your
sent
right
the
hand,
text?
please? You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor, I do.
I'll hear from you.
So on July 9th, I was involved in an incident that led to the filing of a police report, which is central to why we are here today. The report was officially filed by an officer's schedule, but I remember the Officer Magdaleno, which is also who Mr. Terrence mentioned as well. She was the one who interacted with me directly over the phone after the incident. I had already left the scene and returned to my apartment, so Officer Magdaleno called me, and we discussed what happened there. The police report makes some key points that I'd like to highlight. First, there's audio video footage of the incident that has been uploaded to evidence.com, which clearly shows what happened that day. During the conversation with Officer Magdaleno, she noticed that I was she noted that I was genuinely afraid this situation would only get worse if nothing was done. But I was also worried that taking action could lead to more retaliation from Tyree. Unfortunately, that is what happened. And a few weeks later, Tyree placed empty cat food cans under the tire of my car, which clearly meant that his intent was malicious. And there is also video footage of that as well, which is being submitted to the police. Additionally,
what did happen, Mr. Schwenning? What did happen that led to the police being called?
She came out. I later found out that he was accusing me of stealing phones. I didn't know anything about that day on July 9th. I never heard anything about phones being stolen until the 27th when she called me again and we discussed the case again. That's when she told me there was no need to mention it to you because I know you didn't take it. I know those guys didn't take it. She really did. She was pretty clear on that. She also made some statements. Let's see. She attempted to contact Tyree. She said, I attempted to contact Tyree to obtain his side of the story, but every time I called, his phone went straight to voicemail. Based on my investigation, I will be forwarding charges against Tyree Fields for threats of intimidation and harassment to the Olympia Municipal Attorney for review. And I also have a police report on that. With that being said, I'm also filing a cross anti-harassment order against him. I'm in school, Your Honor, and I'm also in the process of moving to a different unit. None of us really need this time to be wasted. You don't need your time to be wasted. Some other communications with the property management. This is directly from her. She said, Josh, I just want to make you aware that we are proceeding with a legal process in regards to the multiple incidents with Tyree. I want you to be aware that he is being served with legal documents that, due to the police report and incident, have your name listed as a complainant. In regards to the incident with your car and the cat food can, we do not show or give residents camera footage. However, I would like to highly suggest you to proceed with obtaining a protection order. We are, of course, willing to provide the police or courts with any requested documents or camera footage that they may need in this process. Please inform staff and law enforcement of any additional incidents and or concerns that you have. And this communication from the property management, which I received on August 6th, clearly indicates that Tyree's anti-harassment order filed later on August 21st is not only frivolous, but also appears to be retaliatory. Both the property management and Officer Magdaleno advised me to file a protection order, and I'm currently in the process of doing that. I'll have that submitted along with all the communications with property management. I'll have the police report as well. And I also have a declaration from staff included that will be included in the anti-harassment order. See, there's also something else that I do want to bring to the court's attention. Tyree has repeatedly disclosed details about my mental health in his filings, which is a serious violation of my privacy. This kind of information is protected by my healthcare information, and that's a clear violation. I will definitely point those out in his petition. And taking all of this into account, the harassment, the retaliation, the violation of my healthcare privacy, and the defamatory statements, I believe it's crucial for the court to grant my request for a cross anti-harassment order, which in that time I'll defend against the false claims Tyree has made, and to seek the protection I was advised to get back in July. And moving on to the items and the sections of the petition that he filed, there's a lot of things I'd like to point out. In the first section, what kind of protection order do you want? The item is choose the type of protection order that best fits your situation. Tyree Fields was instructed to check only one type of protection order that best fits his situation. However, he checked multiple options: domestic violence, sexual assault, stalking, and anti-harassment. This excessive contradictory selection suggests a lack of understanding or an attempt to exaggerate the situation. The next section, how do the parties know each other? The item is check all the ways the protected person is connected or related to the restrained person. The issue with this is that Fields checked. Yes, sorry.
To stop you for a second, what's helpful to me, people who fill out these orders, you and Mr. Fields, I assume you're not lawyers. People make mistakes on those all the time. I don't put a whole lot of, that's not really germane to my decision whether or not I'm going to enter an order or not. So you don't need to point that stuff out to me. What I want to know is you've told me a lot about what's happened and the interaction you've had between the two of you and all of that, which I do appreciate. So you don't need to. I expect people to make mistakes and check wrong boxes and things of that sort. So do you have anything you wish to say about the interactions you've had between Mr. Fields and yourself?
Yeah, I do actually. So let's see. Fields wrote, Joshua came to my room to connect my streaming system, Google Speaker. He uses this is a quote, he uses my Wi-Fi daily. Going to school for computers, he came to my room, he was nude. We have cameras in the apartment building, Your Honor. This is just frivolous. This is baseless. These are false accusations. Let's see. Fields checked multiple items, including this. Oh, sorry. I already read that part. Let's see. The stalking behavior item. In item C, there's no evidence just to support a claim of stalking. I have had no inappropriate contact with Mr. Fields. Mr. Fields was new to the community. We met I was taking out the trash. He was in the smoking section, and I overheard him talking about his router getting hacked. And I'm in cybersecurity. That's my major in school. So it sparked my curiosity. I was interested in engaging. So I did, and I offered some service at network security. It's what I'm doing in my class right now. Network security, not now, but at that time, I was doing some network security for Cisco, and I was very much interested in expanding my experience. So I did that, and I started out was free. Then it ended up to be a continuous thing. It turned out to be like what was supposed to be like 10 minutes turned into like 3 days, and each of those 3 days was just like a couple of hours. He kept trying to find ways to keep me in his apartment. It got to the third day. He had me in his phone. Trying to have his Samsung photos synced with his phone or with his Microsoft account. And along in there, he had me come across some nude photos, and I immediately looked up, and I saw him making a glass of alcohol drink, and I left. And since then, I have not had any contact with him. He's also came to my door aggressively, pounding on my door, demanding for money. I don't owe him any money, Your Honor. These are just false accusations. Let's see. Also, he's checked that I have firearms. I don't have firearms, Your Honor. The policies on the lease agreement says that we are not supposed to have firearms on the premises, and that is just another false accusation. Let's see.
Let me hear from Mr. Johnson there, Mr. Schwenning.
Okay. Yes. Sorry.
That's okay. Mr. Johnson, you're on the telephone there? Can you unmute? *6 will unmute you.
Paging Mr. Johnson.
Okay. I didn't know the phone went to mute.
Okay. Thank you. We probably did that. Could you raise your right hand, please?
Yes, sir.
Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
Go ahead. I'll hear from you.
My relationship to Mr. Fields started back in March, and I had invited him over for a dinner. And he decided he liked the way I cooked and wanted to hire me as a caregiver that made meals for him. And it turned out to be very problematic. I told him that I have a permanent disability that's neuromuscular and skeletal. And I wouldn't be able to work full-time, barely part-time hours, maybe. And we ended up having to narrow it down to 10 hours a week because of the demands. I think he's probably a little upset about that I actually quit that job on April the 8th, where I had only been working for him for about a total of a month and 1 week as a caregiver. It was just requiring too much of my personal time to be able to take care of myself and meet my own needs. He says that I have harassed him, and I haven't even had a word to say to him in the last 4 months, in which I was very glad to keep it that way. Just trying to, keep the peace because we do live in close proximity to each other. I've never made any threats to him. I haven't ever stalked him. I look at these accusations, the allegations, and none of them are true.
Okay. Thank you. I'm going to circle back to Mr. Fields. We've heard a lot. And so clear this up for me. Who owes you money? You're in the position
of Michael Johnson. He owes me for the car.
The car?
Yes, sir. It's $5,000. Mr. Joshua, I have his text message where I gave him money and for me to come upstairs and get the money. That's what happened on July 9th. That's when he closed the door. Prior to that, he has owed me money because of something with Amazon, and he never paid me back. That's a total of $450.
Josh is like, what?
It's 1,000. And for
what's that? No, I'm just here. Just let me ask the questions and get the answers, and then I'll give a ruling on this, Mr. Schwenning. So just wait a minute. Go ahead.
Okay. Terrence Allen's $1,000, and Stephen is $1,000, and I have their text messages. Mr. Swimmer has been he has records of being theft, a burglar, and for harassment. And that's what he did to me in my home because he was putting in the computer in my room.
Is that Mr. Schwenning you're talking about?
Mr. Schwenning. That's the one that I also have he was actually, he has harassment. I have the case number. He has DWLS, 3rd degree. He also charged for burglary and for theft. I also have those case numbers. And he was actually fined for theft, $35,000, and for burglary, $20,000. And that's through Thurston County. He does harass me consistently. And that's why we're having these issues. And he also owes me money as well. Mr. Allen also has DWLS 3rd degree, and he was found guilty in 1, 2, 3 different counties and Thurston County. Mr.
This would
Joshua,
be prejudice, not probative.
Stephen, he came out of jail, of being in jail for 9 years, and became his caregiver. And now they're living together in the apartment. He does carry a knife every single day inside the building. There is absolutely cameras. Sometimes on certain floors they don't work, but coming inside the building, it does work. And that's why I went to management myself because of what they have been doing. The camera on the side when they went across the street, that's when they had Stephen's car. Terrence was in front of me and Stephen was behind me. as well as, like I said, they follow me to the store, they follow me to the gas station and Albertsons. And they getting to the point where I don't even leave the house because they're always there.
Terrence wants to clear this all
That's
up.
one of the reasons why I did the small claims court. When I went to the police
hang on,
department.
I'm going to stop you here. Now, you've made claims against them in small claims?
Yes, I have.
Are those scheduled for hearing?
Yes, sir.
When?
I think you put it in, it's like, I think it's like a month or so.
Okay.
You remember the dates
so,
put on there? She, I'm sorry, I'm asking my caregiver because she writes down the dates and stuff for me. But it's on the calendar. It's like in a month, I believe. Let me look on the calendar. It's okay. Yeah.
Okay.
Oh, for October.
I was just asking out of curiosity.
Yes, October. Yes, sir.
So I'm ready to issue rulings on these cases.
Yeah.
Okay.
Heard enough.
And so,
Your Honor.
yes, Mr. Johnson. Yes, Mr. Johnson.
If I may, I'm a little tired here. I did forget to mention, yes, I did wreck his truck.
Just a second. I'll get to that in a minute.
Terrence is like, shut.
All right.
Relation as well.
With that?
Both. For the truck, he had to send
the truck. Okay, let me get to the truck. Okay.
Oh, yeah.
So what's here now is not the truck. What do you want to say something, ma'am?
Yes. There was, I'd like to say something in behalf of Tyree being a caregiver. I don't know about him being a caregiver.
Okay, so hang on, ma'am, just a second.
Swear you in.
The only thing I want to know is if you have any information about what's alleged to have been going on with these folks.
Well,
and if you got it from him, that's one thing.
No,
if you
no,
witness
this is
things.
all me, has nothing to do with any of this going on, what I observed.
Okay.
The reason why on number 2, we go to number 2, is that's the only place for the laundry facility.
Okay, so hang on just a second,
No.
ma'am, just a second. If you're going to testify, you need to be sworn in. Could you raise your right hand?
Yes, sir.
You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth.
Yes.
Go ahead.
Okay, for him being on floor 2, these gentlemen know that's the only floor. Number 2, number 3 is the laundry facility.
Okay.
So when I'm not there taking care of laundry or whatever, between 4 and 9 or on, he goes and does the laundry. So that's the reason why he's on 2nd floor. Gentlemen. Number 2, he's highly allergic to cats. He does not have cat food. He would not put cat food under somebody's car to kill somebody's cat, which was mentioned. He carries around an EpiPen because he's highly allergic to cats. And the other stuff, I witnessed a couple hostilities between the gentlemen there when I would come into work.
Which gentleman?
The one in the purple and tie, I do believe he cut his hair or something. He usually has it up, pointed up in the air, or whatever.
The one who went to the casino?
No, this was in the last few days. It's all tied back and cleaned up. He was very nice and handsome. Anyway, I was coming in and Tyree was talking to me and he turned around and snapped at Tyree and verbally assaulted him. And I said, oh, wow, we're angry and bitter.
So I don't even know who you're talking about, ma'am. Which one are you talking about?
The gentleman in the purple shirt.
Yeah, the one with the tie.
Yeah.
Okay.
And he says, oh, I just don't like people being in my, and he was cussing. He was raising a voice at me. It wasn't really towards me, but it was towards him. So I witnessed a couple little hostility things and a little animosity. And the gentleman in the blue, I've seen him outside. He does pack a knife. I've seen it when he went to his car one evening and another time since then. So he does pack a knife. I'm sure it's for protection for out there. I mean, everybody carries a knife or a weapon of whatever choice, but
everybody has
I feel that maybe
we're all packed.
that was a threat towards him. Even though he probably didn't mean it as a threat, it was still a threat because of the animosity going on between these people in the building. Secondly, about the hacking, yes. I've had to take my tablet and my phone in and have Motorola and Verizon. Took them 2 days. Somebody in his apartment, in his room, has hacked my phone and my tablet when I go to put my hours in for my work. I work for Consumer Direct Network. as a caregiver. And it took them 2 days to resolve it so I can have my phone and stuff. And then I went back to his
Do you have
home.
any idea who did that?
No, is somebody there that is hacking, and that's what he said, turn off all your Wi-Fi before you go in and everything. I do that, and somebody would turn the Wi-Fi back on just 2 days ago. I was there and they hacked into my stuff again. And I had to go to Verizon again. And they said somebody in that building is a hacker and hacking into your equipment.
Okay. You can go be seated there, ma'am.
Thank
you. Your Honor,
No, Mr. Allen, I've heard enough. Okay? Let me give a ruling here, and then if you want to respond following my ruling, you can.
Sure.
Okay. So what's in front of me, I've heard a lot of things about a lot of things, but what's in front of me are 4 petitions for anti-harassment. You know, anytime anyone's a petitioner or a plaintiff in any sort of lawsuit, whether it's of this sort or small claims, which apparently is coming down the pike, they have a responsibility. They have to show by a preponderance of the evidence that it's more likely than not that the action actually took place. In this case, frankly, Mr. Fields, I don't find that burden has been met. And so I'm not going to enter orders against any of these folks. Okay, so that doesn't address, if someone's hacking you, ma'am, I don't, yes, you should do something about it, but I certainly can't tell who did that. And it doesn't sound like you have any idea who that did either. Mr. Fields, if any of these folks owe you money, you can certainly pursue that in terms of small claims. And apparently you're doing that. That's not going to be resolved now in front of this case. That's in front of, and I'm not sure when it is. I might be on the bench when those things come before the court on small claims, but that'll be handled there. This isn't the place to determine who owes who what. But with regard to, you live in the same place, you're going to run into each other. And apparently, one point you were able to get along where you were given rides to casinos and so forth. That doesn't look like that's the case anymore. But you're going to run into each other. That's just the way that is. Having said all that, I'm not going to enter orders today. For you folk, you 4, Mr. Allen, Johnson, Schwenning, and Klingberg, you guys need to, I would suggest, be on your best behavior out there now. You know that Mr. Fields doesn't want anything to do with you folks at this point. So don't acknowledge him. Don't engage him. Don't do anything that could be misinterpreted by anybody to terms of harassment, because if this keeps up and he comes back, the result might be different next time if he can show that this is a pattern that continues. And I see you nodding, Mr. Allen. I hope you agree and understand that. And I hope everybody else does too. But that's what I'm going to do here for today.
Yes, sir.
And you can get the denial orders will be filed, and folks can get those off the Thurston County District Court website. Awesome. And you folks are free to leave the Zoom call. Mr. Fields, you're free to go.
Thank you.
Thank you, sir.
Thank you.
Wow. For some reason, I think this saga is not over. That there's another part to the story that's going to get played out. Maybe it's in small claims court. Maybe that's the part. But Mr. Fields can take your...
That was the ruling?
Yep. You're free to go, Mr. Johnson.
All right. Thank you, sir.
You're welcome.
I'm going to take a copy of this camera, and he didn't want to see the police report, so I'm going to go get it. It's crazy. He walks around the knife every single day, and they don't do anything about it. I'm going to protect myself. Those go in there, and then these go in this one.
He's not happy about the ruling.
No.
Just keep calling the police, and then
That's what she told me. Just call the police again.
keep calling the police, and then that will be record enough for the judge.
Apparently that's not enough.
Everything has to be documented.
No, this one, that one, Joshua's. That's it. Thank you.
Is this theirs or yours?
It's mine. It was a Saturday thing.
So I'm gonna put this like this with
Yes,
Joe,
ma'am.
and then
Okay.
that.
And these go there.
He's got a very effective piling system.
That's Joshua. He's the one that put the computer in. That's why we're doing that. He did my computer.
I know, but we have to do it.
We have to prove it. They're not done. They're just going to get some more evidence and bring it all back.
Give him another modem. Maybe that helps.
Sometimes it's hard to hatch.
It's hard to prove who hacked
Well,
it.
it is. I'll go and get it. Take these out and put a new one in.
Make sure you make your police reports, that way it's all done to you. And you don't have to pass you outside, they don't have to necessarily come there, just report it and they'll give you.
Well, that's why I went to the bottom floor, so I don't have to see them out.
Get out of that building, you can't just really add. I know, it's gonna get worse now.
I know. It's fine.
You got horrible witnesses.
It's going to get worse now.
The guy who saw him outside, I'll have you.
Thank you, Your Honor. Have
Thank
a
you,
good
guys.
day. God
Good
bless.
luck to you both, sir.
Sorry for being late.
That's all right.
After that, I think we need a little break. I'm going to show you a cactus in bloom. Isn't that beautiful? Look at that big, long flower that shot out of that little tiny... It looks like I don't know what kind of petals those are on a cactus. Little pokey petals. But it shoots out the big, long pink blossom. That was pretty cool. Let's see. Adam knows. It's a Echeveria. Echeveria? Or something similar. But I can tell you this much. This is what I do know about cacti. A blooming cactus is a happy cactus. Okay. On that note, I think it's time for some lunch. Oh my goodness. What a day up there in Thurston. It's been a day and a half for sure. Let me back up a little bit. I need to get the beginning of this. I'm just gonna. How far back is that? Let's see the beginning of this one. At the end of that one. So they leave, and I'm going to start that recording. Okay, I'll start. I want to get the beginning of that one in case I miss something good. All right, can we all say in unison, welcome to Friday? Is that what no. It's not Friday. It's not Monday either. I have changed, Weather Watch, thanks for the catch. I have changed the title of the live stream to say Monday Part 2, or actually says Tuesday, Monday Part 2 Meetup. What a day this was. Welcome to Tuesday. I tell you, it feels like a Monday, doesn't it? After watching some of these courts, it is Taco Tuesday. I think I can convince Mrs. R.A. Hour lunch, please. We can do that. 1 hour lunch. We'll set a timer and come back after 1 hour. Tomorrow is hump day. That's crazy. I think I can convince Mrs. R.A. to go to Taco Time. I think it's Taco Time we go to, or Taco Bell. I don't know which one it is. I think it's Taco Time. There's one place you go where they do honor Taco Tuesday, and it's like we'll get like 40 tacos when we go for the family, and then of course you have to get all the hot sauce your pockets can hold as well. So we might do that. I think we're going to do some soft shell, some hard shell, and lots of spicy sauce. All right, after that, it's time for a break. It's time for a break for lunch. Worked a full half day and took the rest of the week off. Nice. One only eats Taco Bell when they stream in a room by themselves all day. Oh, man. What a day. All right, we're going to keep an eye out for some other courts. There are some big trials coming up. They haven't yet started yet, or they're in jury selection. We're going to be joining a new trial here soon. Before you know it, we'll be back watching a dedicated trial day in and day out. But until then, the courts are spicy. Thanks for joining us for Sarah Boone this morning. That was a lot of fun to go over her new lawyer and the fact that the new lawyer has only 1 month, just a couple days to prepare for trial. And the judge is not giving him any longer. So that'll be interesting. October 7th is the date the judge says to hold for Sarah Boone. So we're in the holding pattern. All right, we're going to be back in about 1 hour. Quick lunch, and that's it. I don't know where the mountains went. See if I can bring the mountains back. Oh, there they are. Have to adjust the shutter and the iris. And the gain just right. So we can now see the wasps on the tree. All right, you guys, tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again in 1 hour with more court hopping and fun goodness. We'll see you guys in a little bit. Bye-bye.